ಅಲ್ಲಿ ವೇದಾಚಲ MB ಅಂತಾನೆ ಇದೆ. ಫೋಟೋ ಚೇಂಜ್ ಮಾಡಿ ಅದ್ರಲ್ಲಿ ಎಕ್ಸಿಟ್ ಆಗ್ತೀರಾ ಸರ್? ಇನ್ನೊಂದು
ಎಕ್ಸಿಟ್ ಆಗಿ ನೀನು ನಾನು
ಫೋಟೋ
ನೀವು ಫೋನ್ ಮಾಡಿ.
Adjournment page wise
area adjustment. Reading the scriptures. ಸರ್ ಇದು ಪೇಜ್ ವೈಸ್ ಹೋಗ್ತಿರಲ್ಲ ಏನಾದ್ರು ಅಮೆಂಡ್ ಆಗಿದ್ರೆ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್
ಯಾರು ಇಲ್ಲ. ಕೆಲಸ ಮಾಡ್ತಾರೆ ಅದೆಲ್ಲ ನಿನ್ನೆ ಮಾಡಬೇಕು. ಲೇಟ್ ಆಗುತ್ತೆ.
ಓ ಈ ತರ ಬರ್ತೀರ ಬನ್ನಿ ಬನ್ನಿ ಬನ್ನಿ.
Now, who has passed this order? Petition total. Why you are moving now?
I'm moving for today's date. Some objection time date post ಆಗಿದೆ ಆಫೀಸ್ post ಮಾಡಿದ್ರು ಆಫೀಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನು ಗೊತ್ತಿಲ್ಲ ಇಂದ ಬರುತ್ತೆ ನಾನು
What is that? You are appearing for whom? What is that urgency for responding?
stay president and it is stay ನಮಗೆ stay ಬೇಕಾದ್ರೆ ನಾನು objection ಹಾಕಕ್ಕೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಇವತ್ತು
Stay application ಹಾಕಿದ್ದೀರಾ vacating ಗ?
objection ಟೈಮ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದೇ ಲಿಸ್ಟ್ ಆಗಿದೆ
ನೀವು objection ಹಾಕಿದ್ದೀರಿ ಅಂದ್ರೆ vacating ಗೆ?
ನಾನು ಕಾಪಿ ಸರ್ವ್ ಆಗಿಲ್ಲ stay ಅಂತ ಕಂಡಿದ್ದೆ I have appeared for stay ಅವ್ರ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ
ಮತ್ ಸ್ಟೇ ವೆಕೇಟ್ ಆಗದಿದ್ರೆ ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ದಿದ್ರೆ ಪೋಸ್ಟ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ? ಹಾಕ್ರಿ, ನೀವು ಹಾಕ್ಬಿಟ್ಟು ವೆಕೇಟಿಂಗ್ ಹಾಕಿದ್ಮೇಲೆ ತಾನೇ ಯು ಹ್ಯಾವ್ ಟು ಮೂವ್ ದಟ್. ವಾಟ್ ಆರ್ಡರ್ ಐ ಕ್ಯಾನ್ ಪಾಸ್ ದಟ್ ಇಫ್ ಇಟ್ ಇಸ್ ದೇರ್ ಇಸ್ ನೋ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ವೆಕೇಟಿಂಗ್ ಮಿಸ್ಟರ್? ಡೇಟ್ ಆಯ್ತು, ಇವತ್ತು ಬಂದಿದ್ರು ಏನಾಗ್ತಾ ಇತ್ತು ಹೇಳಿ? ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ ಕೌಂಟರ್ ಅಲ್ಲ ಇಲ್ಲ. ಆಯ್ತ್ರಿ, ಮೆಮೊ ಏನಕ್ಕೆ ಮೂವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ದೇರ್ ಶುಡ್ ಬಿ ಎ ರೀಸನ್ ಫಾರ್ ಮೂವಿಂಗ್ ದ ಮೆಮೊ. ಇಫ್ ಯು ಆರ್ ಫೈಲ್ಡ್ ಎನ್ see if your application is filed, if there is an interim order, if there is you want to file an application for vacating, there should be an application for vacating for hearing. But application haki vacating, then you move that matter, then we will take that application on vacating, then we will hear. Otherwise what will happen today? Again it will be urgent, there is no application for vacating. Interim order enadru restrict madidara ivattinವರೆಗೂ ಮಾತ್ರ ಅಂತ. Absolute interim order idre you have to file an application for vacating, is it not? You file an application and move, then I will hear that matter. Yes. Orders and admissions, you give that memo except hearing, all matters will take. All orders and admission matters you give that memo tomorrow or day after. File an application for early hearing. Yes. Orders and admissions memo kodi. Yes. Aitha admissions tomorrow. Yes, tomorrow kodi. Yes, give that. Hearing. Hearing, you file an application for early hearing. Yes.
Page wise adjournment, list number 1, page number 1, serial number 1 to 7. Page number 2, serial number 8 to 12.
You are appearing for whom? Wait, it is for filing a paper book. Will function order, yes.
Page number 3, serial number 13 and 14. Page number 4, serial number 15 to 17. Page number 5, serial number 18 to 20. Page number 6, serial number 21 to 21 and 22. Page number 7, serial number 23 to 25. Page number 8, serial number 26 to 29. Page number 26. 26. Ramachandra Patil.
Yes. At the request of council for the appellant, the process week's time is granted to do the need.
Page number 9, serial number 30 to 33. Page number 10, serial number 34 to 37.
Serial number 34, office objection is there. I will complete the same 2 weeks.
What is that maintainability?
Maintainability means we are mentioning 96 provision, but instead of 96,
We'll see when the matter is reached. Yes.
Page number 11, serial number 38 and 39. Page number 12, serial number 40 to 43. Page number 13, serial number 44 to 47. Page number 14, serial number 48 to 50. Page number 15, serial number 51 and 52. Page number 16, serial number 53 to 59. Page number 17, serial number 60. Page number 18, serial number 61 to 69.
Serial number 69.
Yes.
The respondent has.
Data is
There is a There's a
Thank
settlement
you,
work
Amma.
going on, my lord.
Yes. At the request of counsel for the respondent,
Appellant.
you are appellant. Please this matter of next week. Yes.
Serial number 66, Your Honor.
Yes.
66 to pray for 2 weeks time.
You are appearing for
Petitioner.
appellant.
Taker,
Taken. Petitioner is a settlement going on 2 weeks
Yes.
time.
At the request of counsel for the appellant, please this matter of 2 weeks.
page number 19, serial number 70 to 77. C. Babu, connected matter, Subhadra.
70. 74, you are appearing for? At the request of counsel for the appellant, please this matter of 2 weeks. 73.
73, AC Chetan, M. Mohan Kumar.
Yes. At the request of counsel for the appellant, please this matter of 2 weeks. At the request of counsel for the appellant, next week.
77. Appellant.
77, Manjunatha Prasanna, Rangaswamy.
The request of counsel for the appellant, please this matter of 2 weeks. Yes.
Page number 20, serial number 78 to 83.
Serial number 78.
Hmm.
The respondent. Next week.
The request of counsel for
Sitaramarav,
the
Serial number,
please
sorry.
this matter of 2 weeks.
Serial number 80, my lord. I am the respondent.
Yes.
Seek 2 weeks accommodation, my lord.
Yes, at the request of counsel for the respondent, please this matter of 2 weeks.
Great.
page number 21, serial number 84 and 85.
Lord, appearing for 85, serial number 85 for respondent, request for 2 weeks. We inform the other party.
At the request of counsel for the respondent, please this matter of 2 weeks.
Page number 22, serial number 86. Number 1, for orders regarding office objection, fourth time matter, serial number 1, Village Krishna for appellant.
Yes.
The appeal is arising out of order 21/58 application, which was
No, you comply office objection first. Yes. Week's time is granted to comply the office objection.
Second time office objection matter, serial number 2, Satish Chandra R.
Yes. Week's time is granted to comply the office objection.
Serial number 3, Tippeswamy U for appellant.
Yes, Tippeswamy, pass out.
For order, serial number 4, Krishnamurthy HJ, HK Srivastava for appellant.
Yes, I have for recalling that order. Pass out.
Serial number 5, Anjana Devi GS for appellant.
Pass out.
Serial number 6, Arendra PR for appellant.
Pass out.
Serial number 7,
For 2
Sagar
weeks.
Kumar PM.
2 weeks time is granted to do the needful.
Serial number 8, Rajagopala Naidu for appellant, AG Nagaraja.
Filing of paper book.
Respondents with.
Yes. Paper book, how much?
The administration judge also was not present before this unput case, my lord, in the level. Liberally, the matter has been admitted and TCR has been called. And so many occasions, please, my lord, my lord.
Yes, finally, 2 weeks time is granted to file a paper book. Yes,
Serial number 9, C. Doraiswamy for appellant.
I'm filing a paper book. Finally, 2 weeks time is granted to file a paper book.
Serial number 10, M. Arun Ponnappa for appellant.
Government counsel for the appellant has filed a memo taking leave of this court to withdraw this appeal. Memo dated 13/12/2023 is taken on record. The above appeal is dismissed as withdrawn.
Serial number 11, Varam Prasad K for appellant.
Government counsel for the appellant has filed a memo dated 15/12/2023 taking leave of this court to withdraw this appeal. The memo dated 15/12/2023 is taken on record. The above appeal is dismissed as withdrawn.
Serial number 12, M. Satyaraj for appellant. MD Anand.
I appear for the respondents 2, 3, and 4, your lordship.
Week's time is granted. You have
Today itself.
Bernard counsel for the appellant has submitted that PF has been paid, needful has been done, office to verify and proceed further.
Serial number 13, PS Gurumurthy for appellant.
On furnishing PF correct address, issue notice, PS Gurumurthy. You are appearing for whom, Mr.
Respondent.
Respondent. Which respondent?
Respondent number Girish Kumar.
Girish Kumar Yadav.
R1B.
Yes. None appear for the appellant. As a last chance, 2 weeks time is granted to do the.
Serial number 14, G. Srinivasa, KM Chinnama for appellant, Muralidhar, HM.
For dispensation of service of notice for 7 or 17 by the appellant. Where is that counsel for appellant?
Serial number 14, G. Srinivasa.
Sir.
Serial number 15, Chandrasekhar Reddy, ME for appellant, Somashekara KM.
Finishing of PF issue notice. 8 is dead. Learned counsel for respondent has filed a memo reporting death of respondent number 8. Yes, Mr. Learned counsel for the appellant raised 2 weeks time to file necessary application and raised 2 weeks to pay the process to issue notice to respondent number 36. Yes. Non-filing of the paper book. And 3 weeks time is granted to file a paper book.
Number 60, Vishwanatha Shetty for appellant, Vikas Shetty.
Non-amendment of cost title and non-filing of family. Week's time is granted to do the needful. Interim order granted earlier is extended till next date of hearing. Yes.
Number 17, Annaya CV for appellant, Ganapati Bhatt.
Spot inspection, inspect ಮಾಡಿದ್ದಾರೆ. Endorsement.
Furnishing of the correct address of jurisdictional assistant director of land records to issue commission warrant for a second time with regarding to the appointment of the court commissioner. ಏನಾಗಿದೆ?
ಅದು inspection ಆಗಿದೆ ರಿಪೋರ್ಟ್.
ಹಾಕ್ಬೇಕಾ?
Awaiting report ಅಂತ ಒಂದು ವಾರ ಟೈಮ್.
ಯಾವಾಗ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ್ರು? Awaiting commissioner report. Leave this matter next week.
Yes.
Let us see. Where is that government advocate? You are there. Yes, who has been appointed as a commissioner, Mr.
JDL.
JDLR.
Jurisdiction
Verify
JDLR.
just to give an instruction to him.
Yes.
Government advocate, he will secure that report.
Please.
Yes.
Number 18, MK Bhaskaraya for appellant, KV Shyam Prasad.
On filing of print list of print list or preparation of paper book. Our
Direction. Print list.
yes. Who is that Bhaskaraya?
MK Bhaskaraya.
Also,
Serial number 19, Prasanna BR for appellant, Arya Devanand.
non-compliance of the office objection raised on
This is the fourth degree successively I have obtained against 4 others apart from the present appellant in respect to the very same property.
Yeah.
And the proceedings in the trial court commenced so far as this case is concerned in the year 2012. What I am trying to submit for my lord's consideration is paper book is not necessary. Secure the records and here the appeal on marriage. Fourth degree.
what is that IA 2 of 2023?
That is
I am filed the LR application of the sole respondent died.
Hmm.
I am copy also.
You are appearing for the LRs. Notice ಹೋಗಿದ್ಯಾ?
Appear
ಹಾಕಿದೀರಾ?
along with the memo, I filed
For LRs.
the
application for bringing the LR.
Yes, which respondent is that? Sole respondent. Is there any delay?
Delay of.
How many days delay, Mr.? IA 1 of 2023 is filed for continuation of delay of 144 days in filing LR application to bring LRs of deceased to respondent. Peruse that affidavit for the reason stated in the accompanying affidavit. Delay is condoned. IA 1 of 2023 is allowed. Consequently, 2 of 2023 is allowed. Abatement is set aside. IA 3 of 2023 is allowed. LRs of deceased respondent is permitted to come on record. Learned counsel for the appellant is permitted to amend the cost title. Admit agidya? Yes. You amend it.
I will amend.
Learned counsel for the appellant is permitted to amend the cost title. And finally, 2 weeks time is granted to file a paper.
Kindly extend the interim order.
Paper book may not be necessary in the case.
He is ready to file a paper book.
I
He is
file
not
it.
seeking for dismissal.
Half of my life is spent in the litigation.
No, you file it within 2 weeks. You have to file it. Mr.
Please, I will file.
Don't take that advantage and extension of interim order. Interim order. You are not seeking that. Why court has to dispense, Mr.
Already order,
Yes.
that's why I'm not. Kindly
Yes.
extend the interim order.
Interim order granted earlier is extended till next date of hearing. Yes.
Number 20, Sandesh SCR for appellant.
Furnishing of PF acknowledgement, correct address. The appeal memo copy to be issued to the R2 for second time post of service. Where is that? Also,
Number 21, PK Rajagopala for appellant. Edit PV.
Sign for respondent number 1. We have sent the application through RPD and we have got the acknowledgement.
non-compliance of the office objection raised. IA 1 of 2023 is filed by you.
For
Yes.
early hearing, we have
Yes.
sent the application through
On
RPD.
furnishing of correct address and appeal memo copy to issue notice to R2. Who is R2? Notice a service.
Is suspended before the trial. He was placed ex parte before the trial. Therefore, service to RP is not necessary.
That he has to say. He is appellant. He is an appellant. He has to
He
say.
has got the stay of interim stay and he is taking advantage of that. He has
File an
got-
application for vacating. We'll see that if he has not complied, we will vacate it. What has happened to that notice issued to that R2? Correct address, copy to issue notice to R2. 2020 in the notice has not been served to R2. We'll dismiss that appeal, Mr.
he was
If you are taking that interim order, then I will restrict the interim order. Where is that interim order?
What item?
We'll do it. We'll do it. I find some force in the submission made by the granted subject to the defendant not indulging in any act which would result in change in nature of suitable property. Question of this appeal is allowed. Then I will restrict that interim order till next date. If you are not compliant, then it will be. Yes. No, by 2020, you have not completed the service. Taking that interim order. Then I will notice. Admit ಆಗಿದೆ admit ಆದ್ಮೇಲೆ notice automatic ಆಗಿ. Serial number ಎಷ್ಟಿದೆ? 21. Furnishing of acknowledgement correct address. You have not furnished that to PF to that. Yes. Learned counsel for appellant press. Finally, weeks time to furnish correct address and pay the PF to issue notice to R2. Weeks time is granted. The interim order granted by this court 28/3/2022 has been modified till next date of hearing. Yes, let him, yes. We'll modify it. If you are not compliant, then we'll not extend. Yes, you are not paying the process, taking an interim order 2020. Yes, yes.
Number 22, Pushpa Asa R for appellant. Srinivasa Reddy.
Yes, sir. Taking notes. Our menu, just left and we take out fresh notice. R18 has gone out of country ಅಂತಿದೆ ಅದಕ್ಕೂ steps ತಗೊಳ್ತೀನಿ.
Yes.
Two of 23 objections ಹಾಕಿದೀನಿ by mistake officer shown objections not filed ಅಂತ.
ಏನು 2 of
2 of 23 is an application for which I have filed objections ಹಾಕಿಲ್ಲ.
serial number.
In terms of order dated it should take steps in that. So far as
Yes.
the higher number, the last objections of our office that is R17 ಮತ್ತೆ R4 ಸತ್ತೋಗಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಎಲ್ಲಾರ್ಸು ನೋಟಿಸ್ ಹೋಗಿದೆ await ಅಂತ ಆಗ್ಬೇಕು. That is not shown as await. I have made
LRs.
17A and 17B.
Yes. Then we will allow that application. Yes.
Higher number 1 of 23 may be allowed.
23 to bring LRs of respondent number 17.
17.
ನೀವೆಲ್ಲಿ ವಕಾಲತ್ ಎಲ್ರು ನೋಡ್ರಿ ಯಾರು today you have filed. What is your name? Huh? ನಿಮ್ಮ ಹೆಸರು ಹಾಕಿದ್ದೀರಾ ನಿಮ್ ಸೀನಿಯರ್ ಹೆಸರು ಏನ್ ಹೆಸರು? Yes. IA will allow that application. Yes. IA 1 of 2023 is filed to bring to implead LRs of deceased respondent number 17. So and so learned counsel has filed wakalat for LRs of 17 R17A and B. Peruse that affidavit for the reasons stated in the accompanying affidavit. IA 1 of 2023 is allowed. LRs of 17 R17 is permitted to come on record as respondent number 17A and 17B. Office is directed, the learned counsel for the appellant is permitted to amend the cause title. Office is directed to show the name of so and so for respondent number 17A and B. 2 week time is granted to pay the process, issue notice to unserved respondent. Yes. Interim order granted earlier is extended till next date of it.
Number 23, Devi Prasad Shetty for appellant, Chetan Kumar H.
Non-compliance of the office objection raised on IA 1 of 2023 ಏನದು? ಏನಕ್ಕೆ IA? What is that IA, Mr.? Yes. None appear for the respondent. Leave this matter of 2 weeks. Yes. Interim order granted earlier is extended till next date of it.
Number 24, Krishnamurthy MR for appellant, P. Srinivasan.
Finally, 2 weeks time is granted to file a paper book.
Number 25,
Why 8 weeks, madam? 2020, already 3 years, 4 years over. Finally, 4 weeks. 4 weeks, if we are not filed, then we'll dismiss it.
Number 25, P. Mahesh for appellant, Divya Krishna.
It takes steps. It takes time.
Correct address, appeal memo to issue notice to R7 to R10 for second time. Postal Chera R7 to R10. No, Chera. Address is moved. Yes, you have to furnish correct address. Yes, learned counsel for appellant prays 2 weeks time to furnish correct address to pay the process to respondent number 7 to 10. Yes.
I filed an application for bringing LRs of this is appellant number 1.
Appellant is dead. Who are the tellers?
A to D.
Who are the tellers? What is their relationship?
Daughter, son, children.
Yes. Which respondent, which appellant is dead?
Sole appellant.
Whole appellant is dead. Yes, first to the IML out third. IA. Serial number.
25.
Yes, IA 1 of 2023 is filed for bringing a loss of appellant. Peruse that affidavit for the reasons stated in that accompanying affidavit. IA 1 of 2023 is allowed. LRs of appellant is permitted to come on record. Learned counsel for the appellant is permitted to amend the cost title. ಅದಾದ್ಮೇಲೆ ಆರ್ಡರ್ ಬರೀ process. Yes, you amend it. Yes.
Bill number 26, adjourned. Bill number 27, Gurudas BS for appellant, Anantarama GR.
Awaiting service of notice to 9 for second time. No, awaiting service of notice.
ವಾಪಸ್ ಬಂದಿಲ್ಲ ಇನ್ನೊಂದ್ಸಲ ತಗೊಂತೀನಿ
ಯಾರು R9 ಯಾರು ಅವರು ನೀವು
he contended that sisters are not entitled to property because both of us are not that was their contention. That was rejected the contention and allowed this. Property 2003 is entitled to be filed for partition. The contention interest even it has been extended in judgment that the property the sisters are not entitled as per the world law is that has been rejected. Now the appeal is filed. Intent is similar and again contention the Naganasti under purchase model sale everything is good.
No, is there any stay here?
Drawing of the facility is instead, not the proceedings.
I thought, what is the law on that point now? Now law is settled.
Because there are investigator, there is builder, all has been disputed. So ಅದೆಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅದ್ಮೇಲೆ ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡಬೇಕು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡು ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ ರೆಕಾರ್ಡ್ ಬಂದಿದೆ ಫೇವರ್ಬಲ್ ಬೇಕಿಲ್ಲ ನಾನು I argue the matter, we give it 2 weeks time.
What are the issues framed by the trial court?
Because there are issues, investigator mean ಎಲ್ಲ ಇದೆ ಅದು ನೋಡ್ಕೊಂಡು ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀನಿ
ಅಲ್ರಿ ನಾನು ಹೇಳಿದ್ದಕ್ಕೆ ಆನ್ಸರ್ ಮಾಡ್ರಿ. What are the issues framed by the trial court? I asked. Ready Allah. I want to see that there are other issues are there. Then I will just you want see something is passing in the mind of the court. You have to answer. Yes. Yes. What are the issues? Then other issues are there. You are saying that only that. You are just saying that this is covered by decision. He has raised other issues. I will hear. Yes. Yes. Awaiting service of notice to R9. Yes. Yes. Interim order granted earlier is extended till next date appearing.
Bill number 58, Saravana is for appellant.
Yes. IFR 1 of 20 for stay, 2 of 21 for FDP. Why it is posted today? Yes, what is that IA? Now it will not survive for consideration. Appeal admit agidya? Objection to be complied before closure of the office hours, telling which appeal stand dismissed for non-prosecution. Notice to the respondent were published in Vijayanagar newspaper. Absent order specified to engage the matters. Yes, service held sufficient. Appeal against that R1 to R8 is dismissed antide. Huh?
Yeah, for recall.
Notice to the R1 to 8 published in so and so daily newspaper Bangalore edition. Same is accepted. Notice are called, the respondent 1 to are called absent. In order to facilitate the respondent 1 to 8, engage the counsel, release this matter on 4/1/2024. Service has to be held sufficient. Why that this thing? Huh?
24/5/23
24/5/23
dismiss ಮಾಡಿದ್ದಾರೆ.
recall ಆಗಿರ್ಬೇಕು ಈಗ 2012-2023 ಆಗಲ್ಲ ಅದೇನಾಗ್ತಾರೆ ಆಫೀಸರ್
24/5/23 ಅಂತ
24/5/23
ಹಾ ಸರ್.
20 years fine dismissed for non taking appropriate step to ensure the service of notice. ಅದು ಡಿಸ್ಮಿಸಲ್ ಆರ್ಡರ್ ರಿಕಾಲ್ ಆಗಿದೆಯನ್ರಿ? ಯಾವತ್ತು?
8/11/2023.
Recall that order. Recalling that is filed to recall that order. Accepting the reasons for sanction. Recall ಆಗಿತ್ತಲ್ರಿ, ಏನಕ್ಕೆ ಹಾಕಿದಾರ್ರಿ ಅದನ್ನ ಮತ್ತೆ? ಸುಮ್ಮನೆ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡ್ತಾರಲ್ಲ. Also, we'll get that office. Just is making some confusions. There is already an order has been recalled. Also, we will see that.
Number 28, Mahadeva Swami P. Nagaraju DJ for appellant.
Awaiting service of notice to respondent. Liar. That is not a service, Mr. But that is awaiting. When 2021 matter, there is no interim order. Now you are saying that after 3 years interim order, services, you have not taken steps, Mr. Awaiting service. Yes. If you want, you take an hand summons. ಯಾರಿಗೆ? Serving a notice to advocate is not a service. If advocate accepts and filed an wakalat, yes, it can be. Otherwise, it is not in a service, Mr. Party tagali. But if you take an hand summons to the parties, if he is not appeared, then it is in a service. Yes. No, Mr. No, you don't have an interim order for 3 years. Suddenly you want that interim order. Yes. Awaiting service of notice to respondent. In addition, the appellant is permitted to take out hand summons to that respondent. Yes. You serve an hand summons and move that matter. Yes. Mr. From 2021, you have not made any effort to get an interim order. After 3 years, you are seeking for an interim order. How can that grant, Mr.? If there is a, you serve it and move it, Mr. Serve an hand summons tomorrow and move it day after tomorrow. Yes. You don't want to do your work. Yes.
Number 30, appellant. Yes, Ravishankar.
On compliance of the office objection raised on the wakalat filed by. Who is appearing for BS Manjunath?
Will make one submission. Lord, ಇದರಲ್ಲಿ different number 3 and 5 already wakalat. I am the caveator, my lord. My lord, and the subordinate number 68, my lord. BS Manjunath filed wakalat, my lord. The both office objection may overruled, my lord. And I am for the respondent number 1 to 5. RS Ravishankar.
On compliance of the office objection. Office objection.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ ಕಾಸ್ಟೇಟಲ್ ಅಲ್ಲಿ ಮಾಡುವಾಗ ರ್ಯಾಂಕ್ ಆಫ್ ದ ಪಾರ್ಟೀಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲ ಎಲ್ಲಾರು 3ABC ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಸ್ವಾಮಿ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 6 to 12 ಅಂತ ಇದೆ. ಅವ್ರು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ರ್ಯಾಂಕ್ ಆಫ್ ದ ಪಾರ್ಟೀಸ್ ಅಲ್ಲಿ ಕನ್ಫ್ಯೂಷನ್ ಇದೆ. ಎಲ್ಲಾ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೂ ವಕಾಲತ್ ಆಲ್ರೆಡಿ ಅಂತ ರೆಕಾರ್ಡ್.
ಯಾರು? BS Manjunath.
BS Manjunath ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 12 to 16. ಅದರಲ್ಲಿ ಇವಾಗ ಸ್ಟೆಪ್ಸ್ ಟು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್.
Wait, Mr. One by one we'll see. Who is appearing for BS Manjunath? ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಹಾಕಿದ್ರಿ?
I am for the respondent number 1 to 5.
Wait, BS Manjunath ಏನು ಹಾಕಿದ್ರಿ?
Ranking of parties to be stated correctly.
ಅಲ್ಲಲ್ಲ, ನಿಮ್ದಲ್ಲ. BS Manjunath ಯಾರು? ಅವ್ರದ್ದು ವಕಾಲತ್ತಲ್ಲಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಅಂತ. ಅವರು 3A to C.
3A to C ಅಂತ ಕಾಸ್ಟೇಟಲ್ ಅಲ್ಲಿ ಲೆಫ್ಟ್ ಅಲ್ಲಿ ಇದೆ. ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ 12 to 16 ಅಂತ ಇದೆ.
3A to C, D, E. ಅವ್ರು ಹಾಕಿದಾರಲ್ಲ 3A to C. E ವರೆಗೂ ಹಾಕಿದ್ದಾರೆ.
ಓವರ್ ಆಗ್ಬೇಕಿತ್ತು ಆಗಿಲ್ಲ. ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಡೇಟ್ ಅಲ್ಲೂ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರು, ಅದು ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ.
I am asking not for you, office, why office has raised an objection ಅಂತ.
ಅದೇನಾಗಿತ್ತು ಅಂದ್ರೆ ಸುಮ್ಮನೆ ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಅಂತ ಲಿಸ್ಟ್ ಆದಾಗ ಅವ್ರೇನ್ ಮಾಡಿದ್ರು, ಯಾಂಡ್ ಸಮನ್ಸ್ ಕೊಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳಿದ್ರು. ಅವಾಗ ಇವ್ರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿರ್ಲಿಲ್ಲ. ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲಿ 380E ಅಂತ ಇತ್ತು ಸರ್. ಇವರು ಅದನ್ನ ನಂಬರ್ ವೈಸ್ ಅಲ್ಲಿ ಮಾಡಿ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. ಅವ್ರು ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಕೊಂಡು 380E.
ಇದ್ರಲ್ಲಿ ನಿಮ್ ನಂಬರ್ ಬೇರೆ ಬೇರೆ ಹಾಕಿದ್ರಲ್ಲ.
ಅವಾಗ
now that you have corrected, now it is tallying with that wakalat. Yes. Now that what is that other this thing? Office objection in respect of wakalat filed by learned counsel for serial number filed by B.S. Manjunath is overruled. ಆಮೇಲೆ IE ranking to be stated properly. Non-furnishing of PF issue notice to R3A. R3A ಅವರೇ ಅಪಿಯರ್ ಆಗ್ತಾರೆ.
ಮ್ಯಾಂಡೇಟರಿ ಅಂಡ್ ರೆಕಾರ್ಡ್ ಮೇಲೆ
R3A to E.
ಪ್ಲೀಸ್
ಯಾರು?
ನಾವೇ ಮೇಲೆ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎ ಮೇಲೆ ಪ್ಲೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 to 5. ಐ ಫೈಲ್ಡ್ ಐ ಆಮ್ ಕೇವೇಟರ್.
ಅಲ್ರಿ R3A to E ಮಂಜುನಾಥ್ ಅವ್ರು ಹಾಕಿದಾರಲ್ಲ.
ಏನೇ ಮೇಲೆ ನೋಡಿ ಇವರು BS ಮಂಜುನಾಥ್ ಇದ್ರು.
BS ಮಂಜುನಾಥ್ ಸರಿ ರೀ. ನೀವ್ ಯಾರಿಗೆ?
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 to 5.
ಅದನ್ನ ಹೇಳ್ತಾ ಇರೋದು. R3A ಗೆ ಮುಗೀತು.
ಹೌದು ಮುಗೀತು.
ಆಯ್ತು. Now that correct issue address to R3A, R5, R6 to R8 for first time. ನೀವ್ ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಈಗ? R1 to
5 ನೋಡ ಅಂದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1A to E ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪ್ರಕಾರ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ 1 to 5.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಪ್ರಕಾರ ಹೇಳಕ್ ಹೋಗ್ಬೇಡಿ.
ಇವ್ರು ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ 1 to 5.
ಹೈಕೋರ್ಟ್ ಪ್ರಕಾರ ಹೇಳಿ. You are appearing for 1 to 5. Which are that you are appearing for the plaintiff. 1A to you are appearing for 1A respondent number 1, Mr. Adral 1A D ಎಲ್ಲ ಬರ್ತಾರೆ. Lot of confusions that you have made, Mr. Srikantrao. Yes. Then who is appearing for respondent number 2, Birappa and his LRs?
I appear, my lord. I appear for the respondent number 2 and all the LRs. I'm on record.
Wait. You are what's your name, Mr.?
Vedachala, my lord.
Well, you are appearing for 2 and his LRs.
Please, man.
Manjunath is 3 for 3 and LRs. Who is appearing for 4? For 4 and his LRs. Then 5, 6, 7, 8. Now that service has to be.
6 is dead and represented by 4 and 5. 7 Rajamma, the plaintiff, the mother of plaintiff.
No, now that what about that 5, Uma Shankar?
5 is was with us, now he did not join. And whatever order was put is fine.
No, whether you want to dispense or you want to take notice.
I will see that. I will see that.
Yes. Now that service has to be completed. 5, 6 is dead.
6 is dead and represented by 4 and 5.
Represented who are the defendant number 4 and 5.
7 and 8 also dead. 7 and 10 represented by plaintiff. 7.
Adukon memo hakri. We have to pass an order for treating them as an LR. You file in a memo. 6 is dead. He is represented by so and so and a memo, and then we'll pass an order. 7 also we make an
Since the dead represented by legal before the plaintiff's hearing. 8
ಅಲ್ಲಿ ಅವ್ರದ್ದು ನೀವು ರಂಗಮಡ್ಡೆ ಸತ್ತೋದ್ಮೇಲೆ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದಿದ್ದಾರೆ. ಇಲ್ಲಿ ಸತ್ತೋದ್ಮೇಲೆ ಅವರು ಎಲ್ಲಾ ದೇರ್ ಆಲ್ ಆಲ್ರೆಡಿ ಅನ್ ಪಾರ್ಟಿ. ರಂಗಮ್ಮನ ಮತ್ತೊಂದ್ಸರಿ ಪಾರ್ಟಿ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ ನೀವು. ದಟ್ ಈಸ್ ಹೌ ದಟ್ ಕನ್ಫ್ಯೂಷನ್. ಎಸ್, ಯು ಮೇಕ್ ಇಟ್ ಪ್ರಾಪರ್ ದಿಸ್ ಥಿಂಗ್. You correct it office objection, then know that I think all are represented. Yes. Yes. Week's time is granted to do the needful.
Date may be fixed.
ಅವ್ರು ಮಾಡ್ಬೇಕು, ಅವ್ರಿಗೂ ಅರ್ಜೆಂಟ್ ಇದೆ, ಅವ್ರು ಮಾಡಿದ್ರೆ ಯು ವಿಲ್ ಟೇಕ್ ದಟ್ ಮ್ಯಾಟರ್. ದಟ್ಸ್ ಆಲ್. ವಾಟ್ ಇಸ್ ದಿಸ್ ಪಾರ್ಟಿಷನ್?
ಒಂದ್ಸತಿ ಡಿಗ್ರಿ ಆಯ್ತು, ರಿಮೈಂಡ್ ಆಯ್ತು.
See, now all the parties has been served. Only there is a caste listal problem ಇದೆ, ಅದನ್ನ ಕರೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ caste title ಅಲ್ಲಿ then we'll, yes, fix the date. Discrepancy in the name of the defendant number 1. In YS caste title shown is Venkataswamy, whereas shown as a Muni Venkataswamy. The death certificate. Now which defendant number? Venkataswamy. You are a plaintiff or a defendant? Plaintiff. Venkataswamy, son of Narayan Somappa. ಇಲ್ಲಿ ಎಷ್ಟು? ಆಯ್ತು. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಹಿಯರ್ ಇಸ್ he died. Implead Lakshmi Devamma. Yes, who are that LR's wife and children? Discrepancy the name of that prospect is only father name of the defendant. In fact, the procedure is, if he dead, you have to make LR as a respondent and you have to file an application for permission to prosecute. After the judgment, if he died, here you have to make his LRs as a party and seek an IA for prosecuting them, because if they are, that is the procedure. Otherwise, this will be the confusions. Yes. Now, where is that application? Now that notice has to go on that application. Yes. IA number 2 of 21. Yes. Issue notice. Let them come on record, then we'll see condonation of delay. They have to say something for the delay. Yes. No, that's why I said that these are all the problem. If you them as in a party, yes. Then you have to file an application for permission to prosecute them. Yes. Yes. Issue notice on IA 2 of 2021 and also IA on IA 1 of 21. Issue notice on IA 1 and 2 of 2021. Yes. Yes. IA number 3 impleading that. Issue notice on IA 1, 2, 3. Yes. Yes. Let the notice go on. Yes. Yes, yes, we'll see. Yes.
Number 32, Prakash HM for appellate.
Yes, Prakash HM, non-furnishing of PF issue addressed to the respondent first time. Yes, week's time is granted to do the needful.
Number 33, Namatullah Patwal for appellate.
Correct address issue notice to the respondent and main appeal. Week's time is granted. Madam, when that notice has been issued, why that process has not been paid from 2022, madam? Week's time is granted to do the needful.
Number 34, Madhuvan and Deep for appellate.
1 week time may be granted. And I will.
What is that office
clarify.
objection?
Instead
Maintainability.
of mentioning 96, the provision mentioned 43 1R. I will check it here on that. 1 week time may be granted.
You correct it. Not under order 43 rule 1R.
Correct. Yes, sir. I will check the office also on.
Yes. Week's time is granted to comply that office objection.
Number 35, Sona Akun for appellate. Prakash Reddy M.
Alternate counsel for the appellant submission that needful has been done. office to verify and proceed further. Yes.
Will not kind of pass over the matter, there's some urgency in this.
What is that urgency?
We are directing we are execute court to conduct the proceedings in empty number.
Wait. You have filed an application for direction. What is the directions you have sought? No, that is there any stay here for drawing a final degree? Then what directions can be given? Yes, week's time is granted to a learned counsel for the appellant submits that needful has been done, office to verify and proceed further.
Number 36, Srinivasa Singh for appellant, Arun Kumar KN.
2 weeks time is granted to file a paper book.
Number 37, Tikaraman P for appellant, Nagaraja M.
2 weeks to file paper book. Interim order granted earlier is extended till next date of it.
Number 38, Split D for appellant.
Yes. What you want? You want to approach proper court? You have already approached. Yes. Learned counsel for the appellant has filed a memo taking leave of this court to withdraw this appeal. Memo dated 4/1/2024 is taken on record. The above appeal is dismissed as not trust.
39, Ramesh PN, Ganesh Prasad PS for appellant, connected matter.
Other connected to appeals.
No, this in your case also awaiting service of notice.
Yes, I have while you colored, not responded.
R1 to R3.
The R3.
No, who is appearing for 1 and 2? You are not appearing.
They have text. I texted.
Materially, RFA 785 of 2023. Shankar K. Undertake to appear for respondent number 3. Office is directed to show his name. Week time is granted to pay the process. Issue notice to respondent number. Other respondents. Yes. In connected materially, awaiting service of notice to respondent number 12 to 15. Interim order granted earlier. Interim appear ಆಗ್ತಾರ ಅವರು. ನೋಡಿ ಅದು ಯಾರ್ಯಾರಿಗೆ appear ಆಗ್ತಾರೆ. Why again that process and all? You are appearing for which respondent, Mr. Huh? 1 to 4, huh?
For this report, they're all playing.
Second matter ಇದು. Second matter ಇದು. Third.
ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು ಎಲ್ಲ ಪ್ಲೇಂಟಿಫಿಗೂ ಹಾಕಿಲ್ವಾ? 1 to 4. Others they can't. They have not given wakalat. How can they undertake? Second matter 1 to 4, huh? Yes. Umesha, Umesh Learned Counsel, Umesh BN. ಹಾಕಿದ್ದೀರಾ ನೀವು? ಮತ್ತಿನ್ನೇನ್ರಿ? Remaining you have to take. Remaining awaiting service. Yes. ಇದರಲ್ಲಿ 39 ಅಲ್ಲಿ awaiting service of notice to respondent number 12 to 15. Non-compliance of the office objection raised on IA 1 of 2023. ಯಾರದದು ನಿಮ್ದು? Office order? Already given NOC. Non-filing of paper book admitted on. Yes, paper book. Who has to pay the? Paper book you have to pay. Yes. Non-filing of. Yes. ಇವೆರಡರ ಮ್ಯಾಟ್ರಲ್ಲಿ ನಿಮ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿಲ್ವಾ? Entry order 39.1 ಅಲ್ಲಿ awaiting service of notice. Interim order granted earlier is extended till next date of hearing. Learned counsel for the appellant prays finally 3 weeks time to file a paper. 39.2 ಅಲ್ಲಿ interim order granted earlier is extended till next day.
Number 40, Pradeep Kumar RH for appellant.
Plaintiff share is valid exceeding, doesn't exceeding 10 lakhs. See? 57. You are the plaintiff or a defendant? Defendant. Senior civil judge. Now, what is the value of that other properties? ಎಲ್ಲಿದೆ other 6 properties has been included schedule ಅಲ್ಲಿ ಇದೆಯಾ ಡಿಗ್ರಿ ಇದೆಯಲ್ಲ now what is that value? Valuation is 39 lakhs 37,000. Is it? What is the share? How much is the share of that plaintiff?
25 lakhs.
1/4 ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು? ಅದರಲ್ಲೇ ನಿಮ್ದು ಅಪೀಲ್ ಮೆಮೋದಲ್ಲಿ ಹಾಕಿದಿರಲ್ಲ ಎಷ್ಟು ಹಾಕಿದ್ದೀರಾ?
50 lakhs 25,000.
50 lakhs. 1/4 ಅಂತ ಅಂದ್ರೆ
1 lakhs.
Direct counsel for the appellant has submitted that. In the first instance, when the suit has been filed, it has been valid 40 lakhs. Later, how many properties? 6 other properties has been included as a suit scheduled property. Hence, he has the total value of the suit scheduled property is 50 lakhs 25,000. Therefore, the appeal is maintainable before this honorable court. Submission of the learned counsel for the appellant is accepted. Office objection adondena regarding maintainability office objection is overruled. Yes.
Case number to be stated correctly, value of the subject matter, the above RFI filed against.
RFI is filed against the order so also passed by the traditional senior civil. Another 19 value does not exceed it. The above RFI is filed against the order passed by the traditional OS. Value subject matter appeal to be stated correctly. Total value of the claim shapes value to be correctly stated. OS number to be stated correctly in that synopsis. Adon madi. Pass out. Office objection is overruled. You corrected it.
Number 41, Mahesh P for appellant.
2 weeks time is granted to do the needful.
Number 42, Abubakar Shafi for appellant, Ashok P Party.
Non-filing of any document verification total value. 2 weeks time is granted to do the needful.
Number 43, Rakesh B Bhatt for appellant.
2 weeks time is granted to do the needful.
Number 44, Raj Kumar Shetty for appellant.
Is arises from the execution. Application was, award was retained. The execution proceedings, third party, filed an application voting obstruction. As against the order on obstruction application, this appeal is fine. Question of filing is.
Non-filing of that, is it appeal under 96 is maintainable?
Yes.
Or that miscellaneous appeal?
Yes, no. It is a deep degree under 101.
No, what is that order you are challenging? Execution.
Order 21 rule 97. Question has been posed by the third party and that is allowed.
Hmm.
And it is an order under rule 97. It is a deep degree. Rule 101 of.
Ready? Order passed on order 91, order 21, rule 97 is in a.
It's a degree. It's a deep degree. Rule 100.
Order 21 ಇದೆ ಅಂತ ಇದು.
ಒಂದಿಂದ
ಅಂತ ತೋರಿಸ್ತಾನೆ 21 ಅಂತ ಸ್ಟಾರ್ಟಿಂಗ್
ಇಲ್ಲ ಸರ್ ಆರ್ಡರ್ ಒಂದಿಂದ
21 97
97. That's it. Sir.
Yes, it is under 96. Yes. Yes. Yes, yes. Learned counsel for submission of learned counsel for the appellant in respect of office objection is accepted. Office objection is overruled. Non-arriving that objector number 1 before the trial court has an.
These are two separate applications. Common it was not right. A common order.
Common order. Against that other objector, you have filed different. Yes. Submission is accepted. Office objection. Office objection is overruled. Yes.
45. Somashekaraya, RP for appellant.
You file it in that office. Yes.
I agree for the respondent.
Yes. Awaiting this year.
Last case, an order to take up this matter finally.
Prakash Bandila. Yes.
Date may be fixed.
Yes. You file it in that office. Yes. Post this matter immediately after receipt of the TCR. Last time. ಆಯ್ತು ನೋಡ್ತೇನ್ರಿ ಏನ್ ಆರ್ಡರ್ ಐತೆ ಅದನ್ನ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕಾನೆ.
Next day.
ಅದನ್ನೇ ಅವ್ರು ಕೇಳ್ತಿರೋದು ಅಷ್ಟೇ. ಐ ಆಮ್ ನಾಟ್ ಗ್ರಾಂಟಿಂಗ್ ಎನಿ ಅದರ್ ಎಂಟ್ರಿ ಮಾಡು. ವೆದರ್ ಇಟ್ ಈಸ್ ಎನ್ ಅಬ್ಸಲ್ಯೂಟ್ ಆರ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ನೋಡ್ತಾ
Till
ಇದ್ದೀನಿ.
next day.
Meanwhile, undertaken given by that respondent one to put up construction suit to properties placed on record. Yes.
ಮೇಲೆ ಹೇಳಿದೆ, it is also admitted that the respondents would not put up any construction on the suit schedule property till the next date of hearing.
Yes, undertaken by the respondent number 1 to 4 is extended till next date of hearing.
Because
Records ಬರ್ಬೇಕಲ್ಲ.
telephonically communicated.
Yes.
Lala, for this reason, may submit only one submission.
Yes.
The whereas the original plaintiff's husband sold the property from the defendant in the year 1994. He died in the year 1998. Suit has been filed in the year 2018. Mediation. There was no interim on. The defendant has contested this. The plaintiff is not the owner. The defendant is the owner and he is in question adjournment. Finding us to that extent is accepted by the court. Must have been-
No, he is a plaintiff.
Yes, sir. He is the plaintiff.
There is no injunction order. Then why you have undertaken?
Because they have placed the documents before this court.
demolished the building where I am living, madam. Where the plaintiff
Wait, Mr. Sarnath.
The original defendant has sold the property after the expiry of the limitation period.
No, why you have undertaken that there is no injunction against him?
Now in market, defendant number 2 has purchased 8/12/2023 purchase. 12/12/2023 ಗೆ defendant number 2 to 4 purchase.
Yes.
Therefore, we have filed an application before the Supreme Court for impleading.
Yes, leave this matter on 23rd. Yes.
Please.
interim to
Yes, it is not undertaken is continued.
Undertaking will be extended.
Yes.
Serial number 46, Girish MS for appellant.
Yes.
46, Girish MS.
Non-arriving of a defendant number 2 and 3 of the trial court in this court. Counsel submission, para 23 of the appeal. Yes. Where is that? Password.
Number 47, Krishna MS for appellant.
The Karnataka since appellant share is valid not. Yes, mister. What is that value of that this thing? Huh?
20 lakh.
What is the share of the plaintiff? Huh? 1/3 ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು 20 lakhs ಗೆ. ಮತ್ತೆ appeal how can that maintainable? It is less than 6,000. You have to go before the district court. Yes, you file in a memo. Learned counsel for the appellant has filed in a memo seeking leave of this court to the ether appeal. Office has raised an objection regarding the maintainability. Learned counsel for the appellant has filed in a memo seeking leave of this court to withdraw this appeal with liberty to approach appropriate legal forum. Memo dated so and so is taken on record. The above appeal is dismissed as withdrawn with liberty to approach appropriate legal forum.
Then interrogatory application matter. Are this also for appellant? Reddy.
For the respondent.
Yes.
Now this is voted for appearance of respondent notice one.
No, now that IA
Yes.
IA will not survive for consideration at this stage. Matter has to be heard. Why that it is posted in that
Not message.
we'll post this matter to that hearing.
Hearing.
Yes, it has to be in that hearing. Yes. IA 1 of 2016 and 2 of 2018 will be considered along with that main matter. Please this matter for hearing next week. Yes. Next week.
Again, R for appellant. YB, Parthasarathi.
Your Lordship, as regards R4 is concerned, the appellants are the guarantors to the loan R4. R4, my knowledge, it's long ago wound up. It is for the appellants to come with that statement that it is not necessary to take publication on R4. R4 ಗೆ ಕೊಟ್ಟಿರೋದು. R4 is long ago wound up. My knowledge.
No, who is the plaintiff?
Plaintiff is appellant.
You are the plaintiff or a defendant?
I'm defendant number 2.
Defendant number?
I'm a defendant number 2 or respondent number 1.
Yeah, what order you have challenging, Mr. Decree?
The plaintiffs.
IA filed under Order 7 Rule
Order
11.
7 to 11.
Suit for
declaration and consequential injunction against the bank to restrain it from proceeding against them in under Surface Act.
Surface Act. Who has filed Order 7 Rule 11?
The bank.
You are appealing for the bank. Then who is that respondent number 4?
R4 is the
Authorized officer of the Bank of Baroda.
R4 is Vita Computers.
Who is that?
R4 is Vita Computers, the beneficiary of the loan.
Then who is the plaintiff? He is a guarantor.
Plaintiff is the guarantor.
Guarantor.
Please.
ಆಯ್ತು ಅವ್ರ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ಅವ್ರು ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಬಿಡಿ ನಿಮ್ಗೆ ಯಾಕೆ
It's unnecessary dragging time on us. 2016 ಪೆಟಿಷನ್
ಏನ್ ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ
ಏನಿಲ್ಲ.
ಮತ್ತೆ you go and do it in the Surface Act, mister.
Please.
You have a speedy remedy.
Please.
IA 1 of 2023 is filed for. Filed by the appellant seeking permission to take out notice to respondent number 4 through paper publication in Kannada daily newspaper, Samyukta Karnataka, for the reason stated in that accompanying affidavit. IA 1 of 2023 is allowed. The appellant is permitted to take out notice to respondent number 4 by way of paper publication in Kannada daily newspaper, Samyukta Karnataka, in Bangalore edition, on or before
1st February,
hearing date.
29th February.
Yes.
My name may be reflected YP Gokul in place of YV Parthasar.
Serial number. Office is directed to delete the name of YV Parsarthi. Who is that Sujay Kumar? His name is there.
His name is there by
No, but you want that Sujay Kumar name is also has to be deleted, or
no, let that be there. Let that be.
office is directed to show the name of so and so along with that
YP.
HS Sujay Kumar. Delete the name of so and so. So his name, yes.
Serial number 50, D. Srinivas for appellant, connected matter, CM Nagabhushan.
Recalling application, recalling that order. What is that order you want to recall, Mr.
Appeals were dismissed for non-prosecution.
Why? Learned counsel for the appellant is absent. Appeal 17, Learned counsel for the response submitted 385 as moved early hearing. I do not find any reason to absent the matter. However, for offered opportunity to use this matter 2 weeks. ಏನ್ರಿ 2 weeks time ಕೊಟ್ಟಿದ್ದಾರೆ 2006 ಮ್ಯಾಟರ್ ನೀವು even after that you are not appeared. What else?
What had happened, as far as the connected matter is concerned, since it was originally filed as execution first appeal and then converted to MFA and RFA, there was some delay. Adrinda that was subsequently condoned and that was not admitted. However, it was coming along with the main appeal. That was the reason.
ಆಯ್ತ್ರಿ ಅದ್ ಏನಾರ ಇರ್ಲಿ ಕೋರ್ಟಿಗೆ ಬಂದು ಅವತ್ತು ಹೇಳ್ಬೇಕು ತಾನೆ. ನಾವೇ ತಿಳ್ಕೊಳಕಾಗತ್ತಾ ಇದು ಆ ಮ್ಯಾಟರ್ ಅಲ್ಲ ಈ ಮ್ಯಾಟರ್ ಅಲ್ಲ. ಕೌನ್ಸಿಲ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಪ್ರೆಸೆಂಟ್ ಆನ್ ದಟ್ ಡೇ. ನೀವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಅಷ್ಟೇ, ನಿಮ್ ಕೇಸ್ ಮೆರಿಟ್ ಇಲ್ಲ ಅಂತ ಅಲ್ಲ, ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡಿರೋದು ಅಷ್ಟೇ. ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇಸ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಅಪಿಯರ್ಡ್. ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಅನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ವೈ ಯು ಹ್ಯಾವ್ ನಾಟ್ ಅಪಿಯರ್ಡ್. ಏನೋ ನಿಮ್ದು ಹೆಲ್ತ್ ಪ್ರಾಬ್ಲಮ್, ಯು ಆರ್ ನಾಟ್ ಸೇಯಿಂಗ್ ದಟ್, ಯು ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ಸಮಥಿಂಗ್ ಎಲ್ಸ್.
It was the situation and that on that particular time, Lord, I was not well. I was suffering from serious.
Is it that affidavit? I have stated in this affidavit. Yes, Mr. Nagbhushan.
1980.2. 19/2017. I have filed a paper books. The order sheet 10 March.
What is the suit for?
Declaration.
You are the plaintiff or a defendant?
Right.
Plaintiff, your suit is dismissed. There is no order against you. Let him pay.
That I am in question
way they are carrying on, you know.
That is true. It is hurdles, something that case is pending against you, even though there is no any order has passed against you. But it is a counsel who has filed an affidavit.
Lordship may condone, I don't know, date for hearing as a finally.
Yes. IA.
Lordship may impose a heavy cost for the advocates.
Yes, Mr. You pay some cost.
Heavy cost.
Yes.
I have attended all the dates of hearing. That's the reason.
Yes. IA 1 of 2023 is filed for condonation of delay of 38 days in filing in a recalling application to recall that order dated 14/7/2023. There is that affidavit for the reason stated in that accompanying affidavit. IA 1 of 2023 is allowed 38 days delay in filing in recalling application is 38 days in filing recalling application is condoned. Consequently, IA 2 of 2023 is allowed. Order dated 14/7/2023 is recalled subject to condition. Appellant has to pay 10,000 rupees cost to advocates Advocate Clerks Association within 4 weeks from today. Then I will fix the date. Yes. Erade matter last the same. In Erado share 10,000. Leave this matter on 4 weeks on 13th February. Yes, you paid within that 13th February, post this matter for hearing. On that day, we'll hear that matter. If he is not paid, then this order will not be restored. Yes. Subject to condition and that. Yes.
10,000 including both of you.
Yes, 5,000 each. Yes. Year 2 of 20 for impleading. Yes, VP Shivkumar. Grant of leave to file an appeal. None appear. Leaves this matter of 2 weeks.
Prakash P. Abbar for appellant, K. Prakash.
For the appellant.
941 days in delay in filing an appeal. Yes. Why is that delay, Mr.?
3 years delay is there. Only they have stated in the affidavit, Panchayat is going and hence they have not prepared the
No, but what is that suit for?
suit for partition.
You are a plaintiff or a defendant?
Defendant number 3.
Suit is what has happened to the suit?
Suit is defeated.
Yeah.
Their intention is only, if the appellant was in the age of 10 years, he was possessed with some property, that is to be considered as a self-acquired property.
Have you, final degree proceedings has been drawn?
Yes,
No,
that is
but
stated.
CP is state.
Huh?
CP is state.
State by this court.
That's why.
Yes,
The
Mr.
negotiation
Will
for
impose some
settlement.
cost and condone the delay. Anyhow, that final degree.
Fix the next week date for final hearing in Supreme Court.
Yes, but before that, I have to condone the delay.
Along
Yes. Records ಬಂದಿದ್ಯಾ? You are appearing for which respondent, Mr.? You are the plaintiff.
Yes, sir. 1, 2, 3 respondent number here.
Yes, ma'am. Plaintiff.
You are appearing for the plaintiff. You pay the cost 10,000 each plaintiff.
5,000 because there was a negotiation for settlement from their side itself.
No, they
Because they didn't settle the matter and we
for
filed
3
the
years you are waited for negotiation. You go there and get it to negotiation itself.
reasonable. 5,000.
No, you pay that 25,000 together. Yes. Yes. IA 1 of 2018 is filed for condonation of delay of 941 days in filing an appeal. Heard the learned counsel for the parties. Respondent has seriously objected for condonation of delay. Peruse that affidavit. In the interest of justice, IA 1 of 2018 is allowed 941 days in filing an appeal is condoned, subject to condition. Appellant are directed to pay the cost of rupees. Who is other defendant respondents? They are not representing here. You are appearing for 1 to 3, Allah?
1 to 3.
Yes. Subject to condition. Appellant has to pay cost of rupees 5,000 each to respondent number 1, 2, and 3, who are the plaintiff before the trial court within 3 weeks from today. Yes.
Serial number 53.
Within 2 weeks from today. Then we'll post for admission.
Admission.
Yes. Post this matter, admission after 2 weeks. Yes.
Serial number 53. Bharat Kumar Reddy for appellant.
25 days filing in appeal. Yes. Why do you want waste time? Who is appearing for the respondent? Third unrepresented. There is a delay of 25 days in filing an appeal. IA 1 of 2023 is 23 lakh file ಮಾಡಿದಿರಾ 2009 ನೋಡ್ರಿ IA ಯಾವ ಡೇಟ್ ಅದು ಆಫೀಸ್ ಅಲ್ಲಿವರೆಗೂ ಏನದು appeal is filed in time. IA 1 of 2023 is filed for condonation of delay of 25 days in filing an appeal. Notice ಆಗಿದೆಯಾ ಮತ್ತೆ ಆಗಲ್ಲ ರಿಸರ್ವ್ಡ್ ಅಂತ ಇದೆಯಲ್ರಿ ಮತ್ತೆ ಸ್ಪೀಕರ್ ನೋಟಿಸ್ ಆಗಿದೆಯೇನ್ರಿ ಥರ್ಡ್ ಅಂತ ತೋರಿಸಿದಾರೆ ಮತ್ತೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಿಥುನ್ ಥರ್ಡ್ ಅಂತ exponent both on main and appeal. Yes. IA for the reason stated delay of 25 days is condoned. IA 1 of 2023 is allowed. Yes.
Serial number 54. LP Ganesh Gowda for appellant.
Apologize for the interruption. Serial number 52. I pay for extension of it. Remember. That was an in-charge court. It came before.
ಆಯ್ತು ಅಲ್ಲಾದ್ರೂ ಕೂಡ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಿರ್ಬೇಕಲ್ಲ ಅದರ್ವೈಸ್ ಯು ಹ್ಯಾವ್ ಟು ಫೈಲ್ ಎನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ yes you file an application yes
Number 54 LP Ganesh Gowda for appellant.
yeah one of to recalling that order ಯಾರು ಇದೆ ನಾನು
ಬಂದಿದೆ ಅದೇ ನಿನ್ನಿಂದ ತೆಗ್ದಿಟ್ಟಿದ್ದು
ಅವರು NP Kalesh code ಇದಾರಲ್ಲ you are appearing for the Kalesh NP Kalesh code yes what you want password yes password
55 Ganapati R for appellant.
yes recalling that order what has happened mister
Regard to method of valuation.
see what is that order consent for appellant to physically present to regarding the office objection. The declarant consent for appellant should not be able to make out the difference between the dismiss for non-compliance of office. What is that this thing, Mr. Office objection?
Guiding address to post for the deed. And in the last occasion, we made a submission regard to payment of court fee. But that is the reason there was a confusion, but that is the reason.
What is that office raised an objection?
Method of valuation.
Which value court fee?
Objection.
Non-filing of the proof of the document to verify the value. Setting the cost to ensure to the legal service committee directed after lapse of. What is the suit for?
For declaration and
You are the plaintiff.
Please, my suit is dismissed.
Good. What is that value of that, this thing?
Value, that is page number 62, Lord, the value what has been, I mean, court fee what has been paid before the trial court, Lord, I have paid the same court fee. please.
Court fee already, valuation, property value history.
Valuation now, I have placed the guidance value, which is more than 60 lakhs.
Then it has to go before
Yes,
the,
sir.
yes. That office will verify. Have you produced that
I have
guideline?
guidance, I have placed it on.
Yes, you file it in that office.
I placed.
Yes. Where is that IA? Really serial number?
Serial number 55, IA 1 of 23.
IA 1 of 2023 is filed for recalling that order dated 12/7/2023 for the reason stated in the accompanying affidavit. IA 1 of 2023 is allowed, order dated 12/7/2023 is recalled. Yes.
Serial number 56, V. Prabhakar for appellate, V. Raju.
Yes. Condemn. Notice service ಆಗಿದೆಯಾ? Have they filed any objection? ಮಾಡಿದಾರಾ? Where is that other side? Yes, Satyanar Learned Council. Has paid the minimum taking distance. Yes. Yes. There is a delay of 440 days in filing an appeal. IA 1 of 2023 is filed for condonation of delay. Respondent has filed an objection when the matter is called yesterday on 3/1/2024. Respondent number 1 was not present. Even today, when the matter is called, none appear for the respondent. Peruse that affidavit filed along with that application. For the reason stated in the accompanying affidavit, delay of 440 days in filing an appeal is condoned. IA 1 of 2023 is allowed. Admission ಗೆ ಬರ್ಬೇಕ್ರಿ. Matter has to be posted for admission, mister. ಬರುತ್ತೆ next week ಬರುತ್ತೆ. Yes. Yes. ಆಯ್ತು, you move that memo for admission, we'll take it. Yes.
Serial number 57, Jyoti SK for appellate. 57.
340 days in filing an appeal. Notice ಆಗಿಲ್ವಾ? Issue notice.
Serial number 58, RP Sadashivappa.
Notice. Notice.
Serial number 59, SV Bhatt for appellate, Devraj KS. Matter. Not MD.
Yes. Yes, Mr. No, you have, he has completed.
Sale of blood section 92
Yes.
does not blood bar trustees from selling the property blood.
No, that what you say about that maintainability and
Maintainability blood, my submission to your lordship says blood, it is not maintainable for the simple reason. They say blood, a review petition is filed. Two reasons blood they have ascribed. One is your lordships have not stated in so many words that blood the compromise is blood
no, first
Law
thing is he is an aggrieved person, he can file a review petition. That there is no objection.
even there, my lord, my submission would be that, my lord, he is not an aggrieved person in the sense that, my lord, sale of the property, my lord, whether, my lord, that is permissible or not, is an issue, my lord, which arises for your lordship's consideration. If your lordship sees, my lord, the Supreme Court has specifically held, trustees have the power to sell the properties. Therefore, my lord, he has no locus, my lord, to come and say that, my lord, they shall not sell the properties. Therefore, my lord, he has no locus. One. Secondly, if your lordship, my lord, just take, my lord, one judgment for my lord's consideration, which I have given to your lordships. 1996.
Yes. What is?
1996, but AR 1996 Supreme Court Order 878.
Yes.
Paragraph 10, my lord, if your lordships come. At my lord, running page 4.
Yes.
Can I persuade your lordships, my lord, just permit me to read my lord para 10.
Yes.
Let us now see if there is anything in section 9(1)(f) which prohibits giving such directions even if there is a provision to that effect in the scheme. Section 92(1) provides for two classes of cases, namely where there is a breach of trust in a trust created for public purpose of a charitable or religious nature, and two, where the direction of the court is deemed necessary for administration of any trust. The main purpose of section 92(1) is to give protection to public trust of a charitable and religious nature from being subject to harassment by suits being filed against them. That is why it provides that suits under the section can only be filed by either Advocate General or two or more persons having an interest in the trust with the consent of the Advocate General. My lord, please look at this.
Yes.
Can he, my lord, file a section 92? Answer is no. Then, my lord, how is my lord review petition is maintainable? Then, my lord, permit me to further read, my lord. Object, my lord, next 2 lines later. The object clearly is that before the Advocate General files a suit for giving his consent for filing under section 92, he would satisfy himself that there is a prima facie case either of breach of trust or of the necessity of obtaining directions to the court. Relief sought in section 92(1) are indicated in that section and includes removal of any trustee, etc., etc. But I'll skip all that. Can I persuade your lordships come to my lord para 11 kinta? One sentence earlier.
Yes.
One other reliefs which can be sought in such a suit is to obtain the authority of the court for letting, selling, mortgaging, or exchanging the whole or any part of the property of the trust as provided clause F of the relief.
Yes.
We are therefore of the opinion, will not permit me to read para 11 because this is the most important. We are therefore of the opinion, prayer for such a relief, though permissible in a suit under section 92, does not in any way circumscribe or take away from the trustees or the managers of public trust right of ordinary administration of the trust, which would include letting, selling, mortgaging, or exchanging any such property for the benefit of the trust. Therefore, my lord, my submission to your lordships is the trustees, my lord, have the right to sell.
Yes.
And my lord, what has happened is for 25 years, my lord, we have been litigating. It is never ending, my lord. I don't have any relief. At least, my lord, I must go on with my right, my lord, to sell and, my lord, get some property, get some money, and then, my lord, go on with the charitable organizing, my lord, purpose for which I am situated, constituted. 25 years, my lord, we have been litigating between ourselves. Yes. And, my lord, I don't get a penny, my lord. Therefore, my lord, in the interest of, my lord, the trust, we ultimately said we will enter into a compromise, and it came before your lordships. Yes. Now, my lord, please look at the second judgment. Right of the trustees to sell, my lord, is undisputed. Trustee does not bar, my lord, sale of the property by the trustees.
Yes.
Trustees, my lord, have been litigating, my lord, for the last 25 years without any, my lord, any kind of a benefit to the trust. They are in possession.
Yes.
I am, my lord, out of possession. Not a penny. Nothing is happening. And, my lord, they have filed, my lord, the suits after suits. Therefore, my lord, ultimately we thought, my lord, 25 years is too long. And, my lord, we said, all right, we will now settle the matter. You take part of it, I will, my lord, have the other part. Therefore, my lord, we agree. Power of the trustees, my lord, to sell is not disputed. Yes. Secondly, my lord, if they have to file, my lord, a section 92 or, my lord, challenge anything, yes, they'll have to take the permission of the Advocate General, not taken. Therefore, my lord, the review is not maintainable. Secondly, my lord, the second contention that they have raised is, your lordships have not stated, my lord, in so many words that, my lord, the compromise is lawful.
Yes.
Please look at the second judgment, my lord, at page 7, 2006.
Yes.
1 SCC 148.
Yes.
Please come to para 25, my lord, at running page 20, Impatrali.
Yes.
Paragraph 25, my lord, Placitum C, and this one. Page 20. Placitum C.
No, that there is no pagination.
In page, running pages hakidinalla, melgade.
Illa hakilla.
Oh, I'm so sorry, my lord. My profound apologies, my lord. I'm so sorry. My profound apology. Sorry, so sorry. Sorry, my lord, my profound apologies. My lord, the first one is page 4, my lord. I don't know whether, my lord, that AR. First judgment,
Yes,
page 4, paragraph 10 and 11.
yes, that's, I got it. Yes,
Yes. Then please come to, my lord, page 20.
yes.
Sorry,
20,
20, my lord, running page 20.
yes.
Nasidam C ಅಂತ ಬರುತ್ತೆ ಸ್ವಾಮಿ ಅಲ್ಲೇನೆ.
Yes.
It was not necessary for the court to, on the material before it, High Court would have had no reason to hold that the suit had not been adjudged as affirmed by the. It was not necessary for the court to say in express terms that it was satisfied that the compromise was a lawful one. There is a presumption that the court was so satisfied unless the contrary is proved. They must prove that you are not satisfied. Therefore, second contention also is without any merit. Then brought the, sorry.
Yes.
Thirdly, my lord, review. My lord, what is the scope of review? Please come to, my lord, running page 24. Supreme Court judgment on Manu SC 24 ali Swami.
Yes.
Manu SC 1198/2023. Please come to paragraph 16, my lord, 16. At, my lord, running page 28. I'll skip, my lord, the learned judges, my lord, the Supreme Court have Justice Bopanna's judgment, my lord, they have considered everything, all the. Please come to para 16. The gist as aforestated decision is that a judgment is open to review inter alia if there's a mistake or an error apparent in the face of the record. Well, I ask myself, what is the error apparent in the face of the record? There is nothing that they have shown. 2. Judgment pronounced by the court is final, and departure from that principle is justified only when circumstances of substantial and compelling character make it necessary to do so. 3. An error which is not self-evident and which has to be detected by a process of reasoning can hardly be said to be an error apparent on the face of the record, justifying the court to exercise its power of review. In exercise of jurisdiction under Order 47, Rule 1 of Code of Civil Procedure, it is not permissible for an erroneous decision to be reheard and corrected. But even if it is an erroneous decision, can't be reheard. That's what, my lord, they are trying to say. Therefore, my lord, my submission to your lordship says that, my lord, and third, my lord, 5. Other review petition has a limited scope, purpose, and cannot be allowed as an appeal in disguise. Under the guise of review, petition cannot be permitted to re-agitate, re-argue this question which have already been addressed. Therefore, my lord, my submission to your lordship says, even, my lord, on that score also, my lord, the review is not made. That's all. Therefore, my lord, the petition, my lord, is land. In fact, there were, my lord, totally 1, 2, not good years. Look at the number of cases, my lord, that were pending before us. When will you, my lord, another 25 ವರ್ಷ ಏನು ಆಗೋದಿಲ್ಲ? Let's see. C ನೋಡಿ. D, E, F, G, H, I, J, K, L, M. ಇಷ್ಟೊಂದು ಕೇಸ್ಗಳು ಇಟ್ಕೊಂಡು ನಾವು ಯಾವಾಗ ಸ್ವಾಮಿ ಮುಗಿಸೋದು? 25 ವರ್ಷ ಆಯ್ತು, ಇನ್ನೊಂದು 50 ವರ್ಷ. It is in this circumstances, my lord, we said compromise. ಅದಕ್ಕೆ my lord, that saying, court ಅಲ್ಲಿ ಗೆದ್ದವರು ಸೋತರು, ಸೋತವರು ಸತ್ರು ಅಂತ ಹೇಳೋದು ಬಹಳ ಮುಖ್ಯ. ಇದು 20 ನೋಡಿ ಸ್ವಾಮಿ. How many cases? More than 10 cases across each other. Therefore, my lord, my submission is that, my lord, is a case, my lord, which.
No, we'll have it on Monday. No, it is, you have to take either senior counsel or you. Today I have so many other matters. Therefore, if it is there, I can one stretch. Otherwise, I will have it on Monday, next Monday. Monday. Yes, use this matter. Tuesday. Yes, because you have to give a reply on that day itself. I have to close it. Yes. Use this matter on Tuesday. Tuesday, Mr. You will be available. Yes. 12th. Yes, this matter on 12th. Yes, 12th. Yes. Interim order granted earlier is extended till next date of case.
The matter, serial number 60, M. Shiva Prakash for appellant, corrected matter, Vivek Mulla.
They have filed a memo for withdrawal. So, get in the causes.
Memo for withdrawal ಹಾಕಿದಾರ?
Withdrawal ಹಾಕಿದಾರ.
ಕೊಡಿ.
It's filed on
Summary records ಕೊಡಿ.
third.
Copy has been served to you.
Copy has been served to me.
ಕೊಡಿ.
It was filed yesterday.
In all cases, they have filed in a withdrawal.
In all cases.
What is this?
It was a suit for partition and a declaration to hold balance that the sale deed is not binding.
ಏನು settlement ಆಗಿದೆಯಾ?
ಅಲ್ಲ, ಈಗ settlement ಆಗಿದೆ. We are paying him some money.
Therefore,
That
matter has been
basis he
settled.
wants
Therefore,
to-
yes.
Yes.
Learned counsel for others country. Filed in a memo taking leave of this court to withdraw this appeal on the ground that parties have settled the matter out of court. The memo dated so and so is taken on record. The appeals are dismissed or withdrawn. All appeals. Yes.
Number 61, P.S. Rajendra for appellant, attention again.
Yes.
Last occasion,
Hmm.
this honorable court had directed us to take steps by paper publication.
Hmm.
And that was taken. And the matter had been listed on 20th of December. And on that day, R1 placed its party.
Hmm.
Because notice paper publication.
Yes. Now, why it is posted? Admission.
Yes, it is correct.
Hmm.
Yes. But
What is that matter? You are ready?
you will have to be hearing in final, for final hearing.
Not like that. This is an appeal. First, we have the appeal has to be admitted. Then record has to come. Then
The record is already on, it has already come.
no. Are you ready for arguing?
Yes,
on
I am
the
ready.
admission? You argue that.
Yes.
What is?
But the suit filed by this plaintiff, the appellant was the plaintiff before the trial court.
Hmm.
And the suit was for declaration.
Hmm.
But the trial court has failed to address.
So you are
something.
seeking
The
a
only
declaration?
ground- The only ground,
No, your declaration is on the basis of what?
not on the basis of the allotment letter, and we are the legal heirs of the allot,
Who has allotted?
BDA.
BDA.
Earlier CITV. The BDA has allotted the site to my mother.
Hmm.
But what has happened is, my mother was usually called as Angamma. But she is also called as Angamma. That's the only the thing the court has looked at. And my submission before,
Said it and to declare that they are in the succession of Sangama. Hence, his point one is answered.
the first respondent is nowhere connected to our family. He is nowhere connected.
Who?
The first respondent.
Then why you have made him as in a party?
No, he has taken the property allotted to my mother as a legal heir of my mother and got it registered, conditional sale deed. And BDA has failed to register the entire, to the LRs of the entire LRs of the allotment. Except that one who is nowhere connected to the project. And in the entire BDA
So,
records,
where is your plaint? Plaint.
I am not producing it along with the appeal.
What is the declaration you have thought? Declaring that sale deed.
Sale deed
Sale deed
as
executed.
null and void, conditional sale deed as null and void to declare the register it in our name.
Yes. You are appearing for whom, mister? Serial number is to the. You are appearing for the BBMP. BDA. That respondent number one is third unrepresented, huh?
He was placed ex parte even before the court.
Yes. Third, admit. 4 weeks time is granted to file a paper book. Dispense ಆಗಿದೆಯಾ? Admission agdane paper book dispensation ಆಯ್ತು. Admit ಆಗಿದೆ.
ಅದು ಏನಾಯ್ತಂದ್ರೆ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದ್ಬಿಟ್ಟು
How can that?
ಆರ್ಡರ್
Wait. Admit ಆಗಿದೆಯಾ ನೋಡೋಣ ಅದು.
ಇಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿದೆ.
ಮತ್ತೆ ಹೆಂಗ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬರ್ತದ ಅದು? ಆಯ್ತು. Heard admit. Post for hearing. Yes. Yes.
Constantine J.M. Permanent.
Certified copy of the order sheet in execution filed by the respondent.
Now, what is that case for admission? You argue that.
In this case, my lord, the civil court has no jurisdiction, my lord, because the property in question, my lord, it is let out for commercial purpose. On the measurement, the scheduled property measures 28 by 12 feet, my lord. And the civil court has no jurisdiction to entertain this.
No, you are in a defendant.
No, dependent in the suit, my lord.
What is that rent?
Rent 4,600.
It is more than 3,500.
Since, my lord, it is let out for commercial purpose, it is governed by section 2(3)(d) of the Karnataka Rent Act.
That's what I am asking.
Yes.
See, if it is rent is more than 3,500, then
In respect to other premises where it is let out for commercial purpose, my lord. That was section 2(3)(d) of the Rent Act, my lord.
you have any judgment on that point?
Provision is very clear, my lord, in this case. To any premises used for non-residential purpose, but excluding premises.
Nothing contained this act is applicable to premises belong to the state government, Missouri. If doubt arises whether an institution referred to in the subclass above, Missouri releases charitable institution work decision. Any building belong to the cooperative society registered under the cooperative building branch. Any premises being rent on the date of the commencement of this act. It's exceeding. Rupees per month. Yes, also. See, to any premises deemed rent on the date of the commencement of this act or the standard of the rent which exceeding 3,500.
That is to manage. Earlier request branch to section. Where the property is let out for commercial purpose, my lord. And the built area does not exceed 14 square meters, then Rent Act is applicable, my lord. If here the property measures 8 by 12 feet, it does not exceed 14 square meters, my lord.
No, but if the rent is more than 3,500,
Where it let out, irrespective of the quantum of rent, my lord, where property is let out for commercial purpose,
see, section 2 subclass E says any premises,
that is to.
it includes whether it is a commercial or a residential. If the rent is more than 3,500, it is out of the Rent Act.
Very specific.
I agree. There are two classes. If that area is more than 14 square feet,
Then Rent Act is not applicable, my lord.
applicable. And also, if the rent is more than 3,500, then also it is out of that. It is not that.
My lord, for commercial.
No,
purpose.
Mr. The word is used to any premises. You see the definition. Any premises, it includes even.
But section this is very specific, my lord, irrespective of the quantum of rent, where it is let out for.
Where is that? Irrespective of quantum of rent, where is that word is used?
But it is not strictly stated so, to any premises, that's what it says, my lord. Section 2(3)(z), to any premises used for
any premises.
non-residential purpose. But excluding premises, you have a print area of not exceed 14 square meters. Here it is, the scheduled property measures 8 by 12 square feet, my lord. It does not exceed 14 square meters. Therefore, Rent Act is applicable. The result of civil court has
The commercial building, if not exceeding 14 square meters,
Yes.
if the rent is less than 3,500, then HSA Act is applicable. If one of them is there, then it is not applicable, Mr.
It's not. Because where. Because
That is
where
what the
first-
trial court has right in that. That is
No,
not.
no, no.
trial court has not given any finding on that issue, my lord. Trial court has not considered that issue at all.
Therefore, they have entertained suit filed by the parties because the rent is more than 3,500.
No, that issue has not been considered by the trial court, my lord. We have
No, now you are arguing that, therefore there is no
trial
error.
court has not given any finding, my lord. Though we have stated that civil court has no jurisdiction, trial court has not given any finding.
But civil court has jurisdiction in view of the rent.
Because it has not given any finding on that issue, my lord, saying that civil court has jurisdiction.
Not given finding, Mister. It is an admitted fact that it is more than 3,500 square feet. Therefore,
We
appeal,
have questioned the jurisdiction of the trial court, my lord, in entering
that is,
suit.
no, that is not correct.
But trial court has not given any finding on the
Need
issue,
not be,
stating
Mister.
that it is not.
Yes. What is that other point?
So now, my lord, delivery warrant has already been issued because he has been carrying on business. That is the only source of his living, my lord. If in pursuit delivery warrant, if the appellants were to be evicted, my lord, they will be put to great hardship, my lord.
Yes, he wants his premises, he filed an eviction. It is not if it is an HRC act, then certain condition is there that has to be proved. But if it is under that, if it is out of that HRC act, then under the TP Act, he has to give an.
Let out, my lord, for commercial purpose, my lord, the question of the quantum of rent will not come into picture at all, where the property.
Yes, I understood that, yes. You take hand summons or issue notice. In addition, appellant is permitted to take out hand summons to that respondent. Least.
Trial court judgment may be stayed, my lord, made an application.
What is that ground to stay, Mister? You have not made out any ground.
Certified copy of the order sheet, my lord, proves where the delivery warrant has been issued, my lord.
Then they have to.
Meanwhile, if they were to be evicted, my lord, because that is only the source of income for the appellant, my lord.
I say our property, they have to.
That is true, my lord. Ultimately, the appeal will become infructuous, my lord, because trial court has rejected.
No, therefore, you take in a hand summons. Wait, Mister, if the parties is appeared, then you can negotiate.
Till then, my lord, because now the case is supposed to be put to trial court on 2011, my lord. Delivery warrant has already been ordered.
Where is that?
I produced a certified copy of the order sheet in the trial court, my lord. Good is, sir.
Yes.
Because
Or issue notice. Say a further proceedings in the execution petition number 1799 of 2020 till next date of hearing. In addition, issue notice in addition, appellant is permitted to take out hand summons to the respondent.
On the question for the respondent.
This matter on 16th. Yes. Interim order, yes.
So number 63, here you are responding for appellant.
I appear for the appellant, your lordships.
Yes.
The case is filed by it is a plaintiff's appeal. It
Yes.
is a suit for recovery of the money.
Yes.
The appellants are doing a business in year-end shipment cargo business. So they have filed for an outstanding recovery from the defendants for the goods carried out by them. The
Why the
trial court
suit is dismissed?
suit is
Why
dismissed
Why?
on the ground that the invoices and the recovery other documents are produced in not original. So we have approached the court with the section 65 application stating that all originals will lie with this.
Yes, admit. 6 weeks time is granted to file a paper book. Password. Yes, Mr. You are appearing for. You are appearing for whom? That's what that confusion. Usually, appellants are appearing. Yes. Want password? Yes, password, Mr. Day after tomorrow, Monday. Monday. He has some Monday. Yes. Use this matter on Monday.
Number 65, Jagannath KM.
For the appellant. For ejectment filed by the plaintiff landlord has been dismissed. The ground that the lease deed has not been produced. In this case, what had happened, my lord, is the plaintiff purchased the property from the administrator of the deceased owner. The owner of the property died in the year 1986.
Thereafter, there was a series of litigation.
Yeah. Heard, admit. 6 weeks to file a paper book.
Maybe dismissed because the respondent has defended agreement as part in the trial court.
Allah, but how many witnesses has been examined? Our absent agira prashne alla. Paper book for the convenience of the court. How many witnesses has been examined?
One witness.
Yes. They have not examined any witness.
They remain ex parte. They didn't
You
appear.
file in a memo.
Very good.
Yes.
I'll file it now.
Office. Yes.
66 sentence, number 67, Naveed Ahmed for appellate. Number 67,
For the
Naveed
appellant.
Ahmed.
For the appellant below.
Hmm.
The suit of the appellant below.
You are a plaintiff or a defendant?
I'm the plaintiff below.
Okay.
Plaintiff's appeal below. Lord, the suit came to be rejected on the count of notes, order 7 rule 11A for non-disclosure of cause of action.
Hmm.
Not prior to filing, prior to the passing of this order, Lord,
Hmm.
the similar application was filed to the defendant.
Hmm.
Lord, that application came to be dismissed.
Hmm.
Lord, that suppressing that fact, Lord, a new application was filed. Lord, instead of we brought to the knowledge of the court, Lord, that the already application is dismissed and Lord, it is attained finality.
Hmm.
Lord, no, that order has not been challenged by the defendant. Lord, the London civil judge has passed into an order, Lord, rejecting the plaintiff, Lord.
Where is that earlier order passed by that?
Lord, that time, he quotes in the order itself, Lord. Kindly see, Lord, the order. Lord, pair number 5.
Yes.
Lord, I read from pair number 4, Lord.
Yes.
The defendant also filed an application on order 7 rule 11 of CPC to reject a plaint on the ground that the suit is not properly valued and the court fee paid is not proper, and my learned predecessor has rejected such application in detailed order dated 22/4/2022.
Hmm.
Now, once again, Lord, some new application was filed on this similar ground.
Not similar, it's a different ground. There that court fee is not properly paid.
Where court fee is not properly paid, and Lord,
Here that cause of action.
cause of action.
Is there any bar for filing another application on different ground?
Lord, there is no bar, Lord. Lord,
Then-
Lord, the learned trial judge, Lord, is supposed to, Lord, see the plaintiff, Lord, for deciding whether the cause of action is disclosed or not.
Hmm.
Lord, nothing in the order that shows, Lord, that the cause of action is not disclosed in the plaintiff, Lord. Lord, permit me to produce the plaintiff, Lord, to establish.
Hmm.
Lord, the cause of action is disclosed. Lord, the plaintiff. Lord, the reasoning, Lord, kindly see the reasoning.
You have any injunction order during the pendency?
Lord, injunction order, there is no any such injunction order.
What is that your
Notice will be issued.
yes, or issue notice,
Emergent notice, Lord.
emergent notice?
Great.
Serial number 68, C.P. Puttaraju for appellant, Lata Shetty.
But appellant plaintiff,
Hmm.
the plaintiff filed the suit for injunction against the defendant in the suicidal property.
Hmm.
The property belongs to plaintiff in OS number 7032/1997 in the compromise petition
Hmm.
dated 4/6/1998, thereafter registration 1/8/1998.
Who is that defendant?
Defendant is subsequent purchaser.
Hmm.
Earlier, one Timmaya and so executed sale deed in favor of the one Subramanya and Mailaraya.
Who is Timaya? Is it your
Timmaya is the original landowner.
landowner?
In
What
this
is
compromise petition, the Timmaya is the 10th defendant. The GPA holder, one Subramanya and Mailaraya is represented and execute the compromise petition.
Hmm.
The Timmaya is challenged that compromise petition in OS number 9143/1998. Challenge ಮಾಡ್ತಾರೆ. This suit is came to be dismissed on 9/3/2009 on merit. The said Timmaya again challenged the dismissal order of 9/3/2009 in challenged the RFA number 698/2009. The Honorable High Court granted the interim order. Both parties are made in status. The plaintiff appellant belongs to scheduled property in the compromise petition, item number 10, item number 28 in D3 compromise. She is in possession and till now.
No, now that you are claiming a rights on the basis of the compromise petition, that matter is pending before this court.
Yes, RFA 698 pending.
Yes, we'll call this matter along with that. If he succeed, if that RFA is dismissed, then only his right will become. If RFA is allowed, then he has no right to claim.
My claim is, my lord, in 1993, I have been put in possession of the original owner in my. They don't have any possession. The suit for injunction is not maintainable. The decree is not against me. I'm not a party in this.
Where? No, you are claiming the rights on the basis of that you have purchased that property.
In 1993, I was under the
2005.
GPA, I was given possession. In 2005, said it since there was no, there was stoppage of registration.
Yes.
In 2005, registration was
Yes.
completed.
You are appearing for which respondent?
Sole respondent.
Yes. Serial number is
68.
68.
The,
Yes.
the scheduled property till 2021 up to December is a vacating.
They have failed.
One thing. Vacant site. The defendant lift the materials for construction. The plaintiff have filed the approach the concerned police station, lodged the complaint. Again, they filed the suit. They are in the interim order granted. The defendant have constructed the pillar and other things.
No, what is that interim order granted before the trial court?
Not to interfere the defendant, not to put up any construction.
I think you maintain status quo. Who are there?
The order was challenged before this honorable court after a PR. This was ordered. Thereafter, the impugned order has been passed.
No.
Kindly.
No, during the
As
pendency.
possible earlier.
During the pendency of the suit, there is an injunction order against you.
Please, my lord, that injunction order was challenged before this honorable court.
But that has not been set aside.
Order was set aside and it was remanded to complete within
So injunction order has been set aside.
No, it was remanded to be suit to be disposed of
That,
within a
that
period of
means
6 weeks.
from the date of suit till disposal, injunction order is operating. Yes. Now you maintain status quo. Who are there in the position, you maintain status quo. Yes.
My lord, the difficulty is, my lord, it's already the only is filed against me. The scheduled property belongs to me and my brother Devraj, who is already constructed and is in possession of the property from 2001.
I am granting status quo if you are there in the position. Otherwise, during the trial, there is an injunction. Your appeal itself has been, the trial court has not accepted, this court has not accepted that you have constructed, you are in the position. Even in this appeal also, you have not succeeded. Directed to dispose of the suit doesn't mean that, is it that you have succeeded? You are not succeeded at all.
Any records may be called off, my lord, and matter may be taken.
No, I am asking that injunction order not to interfere is there. There is no discussion.
My lord, it was status quo order was passed.
Status quo.
No,
That's what I am.
status quo, my lord.
Where is that? Show me that order, mister. What is the order passed by this court and the order passed by the trial court? Both.
This court remanded to the
Order ಕೊಡ್ರಿ ನೀವು ಒಬ್ರೊಬ್ರು ಒಂದೊಂದು ಹೇಳ್ತಾ ಇದ್ರಿ ನಾನೇ ಓದ್ಕೊಂತೀನಿ. Give that order passed by the trial court, mister.
trial court till the disposal of the
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಡ್ರಿ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಟಿಲ್ ದ ಡಿಸ್ಪೋಸಲ್ ಅಂತ ಹೇಳ್ತಾರಾ? ಆಯ್ತು ಕೊಡಪ್ಪ, ನಿನಗೆ ಇದೇ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ ಕೊಡೋದು. ವಾಟ್ ಇಸ್ ದ ಆರ್ಡರ್ ಪಾಸ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್? Where is that? You have the copy of the trial court. Yes, use this matter on Monday. You produce the trial court order as well as high court order. Yes.
Monday, Tuesday.
Tuesday. Yes.
Number 69, Adjournment. Number 70, is Sheshagiri Rao correct?
Yes.
The appeal has been preferred by the defendant.
Defendant appeal.
Defendant was a tenant under the plaintiff respondent.
Yes.
And he who vacated the premises on 9/9/2021
Yes.
Before that, he has not paid the rent for a period of 6 months, as per his admission.
Yes.
However, the plaintiff would say in the cross-examination,
Hmm.
no, he has paid rent. Only for 4 months he was due. That is the controversy between the parties. The rent agreed was 55,000 rupees.
Hmm.
The rent collector was the PW2.
Yes.
I will just pass on the cross-examination of PW2 to the kind notice.
No,
of the
you was a tenant.
The thing is,
Hmm.
I was a tenant.
Hmm.
I handed over the premises on 9/9/2021.
Hmm.
This has been admitted by PW2 in his cross-examination. And after 2021, 9/9/2021, there was no liability for me to pay the rent. However, this court below has said it. You are liable to pay around about 13 lakhs and that. Instead of granting a decree in favor of the defendant, directing the plaintiff to pay return 3,20,000 rupees to me. That is the deposit amount. ನಾನು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟು ಸೇರ್ಕೊಂಡಿದ್ದೀನಿ. 5 ಲಕ್ಷ ರೂಪಾಯಿ ನಾನು ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ. 5 ಲಕ್ಷ ರೂಪಾಯಿ the controversy between the parties is how much the plaintiff wants to return to the plaintiff, the defendant, was the question. Keeping all other things left open, court has decreed the suit merely on the plain basis of the plain allegation. Now I request this honorable court to take out the relevant portion of the the judgment of the
The
trial court.
plaintiff is entitled to refund of the arrears of the rent of rupees.
ನಾನು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದಕ್ಕೆ ಒಂದು ಪ್ಯಾರಾ ನಂಬರ್ 27/1/2023 ನಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ is important.
ನೀವು plaintiff is the tenant or a landlord?
ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ.
Plaintiff is the tenant or the landlord?
I am plaintiff was the landlord, I am the tenant. Defendant is the tenant. PW2 is the rent collector. And PW1 is the plaintiff who admits that PW2 was collecting the rent. Now I'll just invite the attention of this honorable court to para number 18 of the judgment, ink page number 34.
Yes.
Para number 18.
Yes.
PW2, who is a supporting witness to the plaintiff, who is a collector of rent for the plaintiff, he has filed his affidavit. In his cross-examination, it is forthcoming since 30 to 35 years he is working with the plaintiff as his personal assistant. It is forthcoming in the cross-examination that it was not written in the check of February 2021 that the defendant is paying for the month of April 2020. The next portion. Up to February 2021, the defendant has paid the rent through check and he has deposited this same in the plaintiff's bank account. He has admitted the defendant has vacated his two premises in the month of September 2021 on 9/9/2021. He also admitted that the defendant has not paid rent for the month of May 2021, June 2021, July 2021, and August 2021. But I have stated, ನಾನು 6 ತಿಂಗಳು ಕೊಡಬೇಕಾಗಿತ್ತು. March 2021 and April 2021 also I have not paid it. But PW2 says, ಇಲ್ಲ ನೀವು
4 ತಿಂಗಳು ಅಂದ್ರು.
You have paid March and April also, and your liability is only for the month of May 2021, June 2021, July 2021, September 2021. If it is calculated, the defendant has to pay 2,20,000 rupees at the time of vacating the premises. So far as another portion is para number 21, para number 22, page number 36.
Yes.
ಅದರೊಳಗೆ ಬಾಟಮ್ ಇಂದ 6 ಲೈನ್ ಮೇಲ್ಗಡೆಗೆ the calculation made by the plaintiff in this plaintiff is not correct. The defendant has paid an advance of rupees 5 lakhs towards the suit premises and it is with the plaintiff at the rate of 55,000 per month for 6 months if it amounts to 3,30,000 rupees. But as per the evidence of PW2, the arrears of rent is only 4 months. 4 months from May 2022, August 2021, which amounts to 2,20,000 rupees. Nam advance no avaru ಡಿಡಕ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ 3,30,000 ನನಗ್ ಕೊಡ್ಬೇಕು. ನನ್ನ ಹೇಳಿಕೆ ಪ್ರಕಾರ ಹೋದ್ರೆ ಅವರು 2,20,000 ನನಗ್ ಕೊಡ್ಬೇಕು. The decree which has been passed by the trial court. Para number 26, page number 39. The another defense by the defendant is that he has vacated the premises on 9/9/2021. Since then only he is liable to pay the rent in this regard to these premises. In the case and the court commissioner is appointed to verify the damages and report the same. As regards on behalf of the plaintiff that there is no damages to these premises, but the defendant had not vacated the premises on 9/9/2021, but only in the month of November 2022. That is on 21/11/2022. The defendant has vacated and hand over possession of the food premises. Till then, he is liable to pay the agreed rent, which includes 10% enhanced rent in the agreed to the said premises. But PW2 says that you have vacated on 9/9/2021. PW1 says that you have vacated on 2/9/2021. But the learned judge says you have vacated only in the month of November 2022. During the pendency of the suit. The suit has been filed on 2/8/2021. I vacated the premises on 9/9/2021. The fact that I have vacated the premises is forthcoming from the evidence of PW2.
Yes.
PW2 in the cross-examination conducted on 27/1/2021 has stated you vacated and handed over possession of the property. ಅದಕ್ಕೂ ರೆಂಟ್ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಿದ್ದಾರೆ November 2000 because the commissioner went and inspected entire damage.
What is the degree passed by that trial court?
The page number 41, para number 24. The suit of the plaintiff is hereby decreed in part with cost. The plaintiff is entitled for the refund of arrears of rent of 13,28,000.
Plaintiff is entitled for refund of the arrears of the rent.
Plaintiff is entitled for refund of arrears of rent. Recovery ಇರಬೇಕು.
Adana, that's what that I
entitled for refund ಅನ್ನ.
Refund the direction to he has to pay that amount or what is that? That's what
ಏನು ಮಿಸ್ಟೇಕ್ ಆಗೋಗಿದೆ.
plaintiff is entitled to
refund of arrears of
recovery of arrears of
recovery of arrears of rent ಅಂತ
rent
ಬರ್ಬೇಕು.
13 lakhs. That's what that. Then
ನಾನು ಬಾಡಿಗೆ ಕೊಡ್ಬೇಕಂತಿಲ್ಲ. ನನಗೆ ಇನ್ನು ಅವ್ರು ನನ್ನ ಪ್ರಕಾರ ಹೋದ್ರೆ 2,20,000 ಕೊಡ್ಬೇಕು. According to the plaintiff, he is liable to pay 3,30,000 rupees.
Yes.
And they have filed the execution petition.
Yes.
And yesterday they have come for seizure of the movables.
Yes.
And the matter stands posted tomorrow, that is on 5th, before the trial court.
Yes. What is that execution petition number?
Execution petition number EX 2353 of 2023.
Have you stated in this IA?
ಇಲ್ಲ ನಾನು ಹಾಕಿದ ಮೇಲೆ ಹಬ್ಬಿಲ್ ಹಾಕಿದ ಮೇಲೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಇವ್ರು ಹಾಕಿರೋದು.
Or issue notice stay of further.
ಇಲ್ಲ ನೋಟಿಸ್ ಗಳು ಜಾರಿ ಆಗಿದೆ.
ಯಾರಿಗೆ?
ಅವರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ has been served.
This is not first time it's coming.
Notice ಆಗಿದೆ. It is not first time.
Notice ಆಗಿದೆಯಾ?
Notice.
Notice has been served.
Yes. Heard the learned counsel for the appellant. Respondent is served unrepresented. Stay of further proceedings in execution petition number
2353 of 2023.
pending before
Same court. Okay. 49th additional civil court.
49th additional city civil and session court Bangalore
59, I'm sorry, madam, 59.
59 additional cities civil court Bangalore still next date of hearing. Yes.
Appellants are a defendant. Plaintiff
Yes.
side is sued for the partition.
Notice. Notice.
Right.
Delay. there is a,
300 next till ಬರೋವರೆಗೆ ಯಾಕಂದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗ್ತಿಲ್ಲ 300 ಅಡಿಗೆ 1500 ಅಡಿ ಅಂತ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟು.
no, what are you doing all these days when there is a decree against you? You have not filed an appeal in time.
ಅದೇ 300 ಅಡಿಗೆ 1500 ಅಂತ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ರು. ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗ್ತಿದೆ ಟಿಲ್ ಅವ್ರು ಬಂದಿದ್ ಮಾಡ ನಾನು ಸರ್ವ್ ದಿ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಆಲ್ಸೋ.
FDP you are challenging.
Yes, ma'am.
What is that?
Suit filed by the respondent plaintiff for seeking off share in the item number 1 and 2. Kindly page 16 operation order of
ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ FDP?
ಆರ್ಡರ್ ಅಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 1 ಗೆ ಆಫ್ ಶೇರ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. Suit has been rejected in respect of 2 and 3 minutes. Item number 1 kindly see my next 70 page ಅಲ್ಲಿ ಇರೋದು all that part and parcel of the property bearing 160 ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಅಂತ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ. ಆದ್ರೆ ಇದನ್ನ ಕ್ಲೈಂಟ್ ಅಲ್ಲಿ they have described. Kindly see my client I have produced page 38.
What is that stay you are seeking, Mr.?
The proceedings of the FDP are the based on the execution they have filed, taking possession of the 1500 instead of 300.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ರೀ?
ಅದರಲ್ಲಿ ಪೇಜ್ ಇದರಲ್ಲಿ 162 ಸರ್ವೆ ನಂಬರ್ ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ ಅವರು ಟೋಟಲ್ 600 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಇದೆ ಹಾಫ್ ಶೇರ್ ಕೊಡಿ ಅಂತ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಿರೋದು.
ಎಲ್ಲ ಐತ್ರಿ ಡಿಗ್ರಿ ಎಲ್ಲ ಐತ್ರಿ.
ಡಿಗ್ರಿ ಮೇಲೆ ಪೇಜ್ 69 judgment degree of the OS. ಅದರಲ್ಲಿ first the partition and separate position of the plaintiff's half share in item number 1 of the suit scheduled property by means and bounds shall be effected by the appointing court commissioner.
Only one item.
Only one item. Next page ಅಲ್ಲಿ schedule details of the schedule is there.
ಈಗ ಏನಾಗಿದೆ ಈಗ?
ಇದರಲ್ಲಿ ಈ ಐಟಮ್ ನಂಬರ್ 1 ಇರೋದು ಟೋಟಲ್ 600 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಮೇಲೆ. ಅದರಲ್ಲಿ 600 ಅಲ್ಲಿ 300 ಅಡಿಗೆ ಮಾತ್ರ ಆಸ್ ಪರ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್ ದೇ ಆರ್ ಎಂಟೈಟಲ್. ಅವ್ರೇನ್ ಮಾಡಿದಾರೆ ನಮ್ದು ಅಡ್ಜಸೆಂಟ್ ಲ್ಯಾಂಡ್ ಸೇರಿಸ್ಬಿಟ್ಟು ಟೋಟಲ್ 3000 ಸ್ಕ್ವೇರ್ ಫೀಟ್ ಅಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ನಾವು ಕಟ್ಟಿದೀವಿ. ಅವರು 1500 ಗೆ ಎಂಟೈಟಲ್ ಅಂದ್ರೆ ಕಮಿಷನ್ ಹ್ಯಾಸ್ ಬೀನ್ ಫೈಲ್ಡ್ ರಿಪೋರ್ಟ್.
ಅಲ್ರಿ ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಎಷ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಇದೆ?
ಅದು ಕ್ಲೈಂಟ್ ಅವರೇ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಕೈಂಡ್ಲಿ ಸಿ ಮೇಲೆ ಪೇಜ್ 38 ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಕ್ಲೈಂಟ್. Plaintiff para 4 ಅಲ್ಲಿ the plaintiff and the father of the defendant had decided to extend the business activity and as it decided to purchase the vacant site for the purpose of running the industry after construction of a shed. According to stated Miller 8/8/1980, they had jointly purchased half portion of the site number 4 measuring 600 square feet in survey number 162. Item number 1 is Miller bearing number 1 survey number 62. That is, they have said it also. I have produced Miller.
ಈಗ
page 54 ಅಲ್ಲಿ
ಈಗ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
ಆರ್ಡರ್ ಕೈಂಡ್ಲಿ ಸಿ ಮೇಲೆ ರಿಪೋರ್ಟ್ ಕೋರ್ಟ್ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅದ್ರಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಹೇಳಿದ್ದಾರೆ ಅಂದ್ರೆ 88 ಕೈಂಡ್ಲಿ ಸಿ ಮೇಲೆ ಪೇಜ್ ಅದ್ರಲ್ಲಿ ಅವರು ಟೋಟಲ್ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟು ಈಸ್ಟ್ ವೆಸ್ಟ್ 40 ಫೀಟ್ ನಾರ್ತ್ ಟು ಸೌತ್ 75 ಫೀಟ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್.
ಇಶ್ಯೂ ನೋಟಿಸ್ They are further proceedings in FDP number 14 of 2007 pending in first additional city civil and session judge Bangalore till next date of hearing.
For matter number 1, item number 3, Display Swami U for appellant. Last for matter item number 3, Display Swami U. Orders, serial number 4, Krishnamurthy HJ. Serial number 5, Anjana Devi PS. Serial number 6, Narendra PR. Serial number 40, D. Srinivas. Serial number 40, D. Srinivas.
Memo for dispensation of service of notice to R7 to R17.
We made the party because they are the tenants, Your Honor. We are not seeking any relief on them. Hence, the issuance of notice does not arrive. 7 to 7 respond.
Has filed a memo seeking dispensation of service of notice to R7 to R17. Memo is taken on record. Service of notice to R7 and 17 is dispensed at the risk of the appellant. Non-compliance of the office objection on IA 1 to 3 ಏನದು?
That already I been complied on 10/10/23 itself. Notice has been served and memo also filed in regard.
ಅಲ್ರಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರೇನ್ರಿ ಅದರ್ ಸೈಡ್ಗೆ?
Other side served the copies. Is there the acknowledgement?
Who is dead?
Who is R1?
R1 is dead.
Yes.
Huh? 2 again ಕಾಪಿ ಕೊಡ್ತಾರ್ರಿ. 2 ಎಲ್ಲಿ ಸರ್ವ್ಡ್ ಅಂದ್ರೆ ಯಾರು 2?
ಅಲ್ಲ 2 is no more. He is dead.
ಆಯ್ತ್ರಿ ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಯಾರಿಗ್ರಿ?
Other side not served ಅಂತ sir.
ಎಲ್ಲ application A1, appellant 1 from appellant 1 ಗೆ appellant 2 and respondent number 2 has died during the pendency of this.
ಯಾರು ಸತ್ತೋಗಿದಾರಪ್ಪ?
Appellant 1.
ಅಪ್ಲೈಂಟ್ 1.
ಹಾ.
ವೆಂಕಟರಾಯಪ್ಪ.
ವೆಂಕಟರಾಯ್.
ಅದಕ್ಕೆ ಏನ್ ಹಾಕಿದಿರಾ? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಿರಾ?
ಹಾಕಿದ್ದೀವಿ.
ಯಾವ್ದು IA?
IA 426 456 of 23.
456 of 23.
Appellant 1 ಗಾದ್ರೆ 789 of 23 sir. Next page ಅಲ್ಲಿ sir item number 4. Appellant number 1 ಆದ್ರೆ 789 of 23.
789.
789.
ಅಪ್ಲೈಂಟ್ ನಂಬರ್ 1 ಯಾರು ಎಲ್ಲಾರ್ ಸರ್?
LRs already.
What is their relationship, mister?
They are the daughters and son's wife.
Yes, who is appearing for other side? ಅದ್ರ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಾ? ಇಲ್ಲ.
Copy not served ಅನ್ನೋದೇ objection ಇಲ್ಲ.
That already served. I have been furnishing this.
Yes.
ಮುರಳೀಧರ್ HM.
Yes. IA 7 of 2023 is filed for continuation of delay of 50 days in filing an LR application to bring LRs of appellant number 1. Peruse that affidavit. Delay of 50 days in filing an LR application is condoned. IA 7 of 2023 is allowed. Consequently, IA 8 of 2023 is allowed. Abatement is set aside. IA 9 of 2023 is allowed. LRs of deceased appellant number 1 is permitted to come on record. ಇನ್ಯಾರು ಸತ್ತೋಗಿದಾರಪ್ಪ? ಅಪ್ಲೈಂಟ್ ನಂಬರ್?
Appellant number 2.
1 2 3.
ಲಕ್ಷ್ಮೀ ದೇವಿ.
Lakshmi Devi.
ಅದು ಯಾವ್ದು?
IA 1 IA 2 IA 3 of 23.
IA 1 to 3 ಇದರಲ್ಲಿ 234 ದಿನ ಡಿಲೇ ಇದೆ.
Also.
ಡಿಲೇ ಕಂಟ್ರೋಲ್. IA is allowed. Permitted to come on record. ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿ. ಇನ್ಯಾರು ಸತ್ತೋಗಿದಾರಪ್ಪ?
R2 ತಿರೋಗಿದ್ದಾರೆ. ಆಗಿಲ್ಲ ಸರ್.
ಆಲ್ಸೋ ಸಿರೋಗಿದಾರಾ?
R2.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಹೌದು ಸರ್.
ಯಾವ್ದು IA ಯಾವ್ದು?
456.
Issue notice on IA LRs. Issue notice on IA number 456 of 2023. Yes. You amend that cost title.
Much.
Yes. Our appellant LRs amendment ಮಾಡಿ. Yes.
Number 80, MK Bhaskaraya for appellant, KV Shyam Prasad.
Unfiling of
ಪೇಪರ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಸರ್. ಪ್ರಿಂಟ್ ಲಿಸ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಆಫೀಸಲ್ಲಿ ತರಿಸ್ಕೊಂಡು.
Learned counsel for the appellant is that they have furnished the print list for preparation of the paper book. Office to verify and proceed further.
Serial number 20, Sandesh CR for appellant. Serial number 20, Sandesh CR.
Furnishing of PF correct address and appeal memo copy to issue notice to R2 for second time as consenting in a transport. Week's time is granted to do the needful.
Serial number 28, Saravana S for appellant.
IFR. Yes, 28.
Wide order dated so and so R1 to 8 are dismissed ಅಂತಿತ್ತು. Serial number 28 sir.
ಏನಪ್ಪ ಆರ್ಡರ್ ಶೀಟ್ ಗಳು ನೋಡೋದಿಲ್ಲ ನೀವು. ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ರೀಕಾಲ್ ಆಗಿದೆ ಅಗೇನ್ ಯು ಆರ್ ಶೋಯಿಂಗ್. ಎಷ್ಟು ಕನ್ಫ್ಯೂಷನ್ಸ್ ಆಗುತ್ತೆ ಗೊತ್ತಾ? ಎಂಟೈರ್ ಫೈಲ್ಸ್ ನಾನು ಕುತ್ಕೊಂಡು ಕ್ಲರ್ಕ್ ಕೆಲಸ ಮಾಡ್ಲಾ ಜಡ್ಜ್ ಕೆಲಸ ಮಾಡ್ಲಾ ಆರ್ಡರ್ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ರೀಕಾಲ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಗೇನ್ ಯು ಆರ್ ಶೋಯಿಂಗ್ ದಟ್ ಡಿಸ್ಮಿಸ್. ಏನ್ ಜ್ಞಾನ ಇರೋದಿಲ್ವಾ ಕೆಲಸ ಮಾಡ್ಬೇಕಾ? ಎಸ್ ಎಸ್ ಮಿಸ್ಟರ್. Now that that has been recalled, now that you have to take in steps for R1 to R8. Paper publication ಗೆ ಹಾಕಿದ್ದೀರಾ? ಎಲ್ಲಿದೆ? Paper publication ಅಲೋ ಆಗಿದ್ಯಾ? Recalling ಆಯ್ತ್ರಿ. Now that you have to pay that process. ಏನಕ್ಕೆ ಬಂದಿದ್ದಾರೆ? ಏನು ಅಂತಾರೆ ಅವ್ರು ಏನಂತಾರ?
ಇವತ್ತು ಸ್ಟೇಗ್ ಬಂದಿದೆ ಸರ್. ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್ ಅಂತ ತೋರಿಸಿದ್ರು ತಪ್ಪಾಗಿತ್ತು, ಅದಕ್ಕೆ ತಾವು ಕರ್ಸಕ್ ಹೇಳಿ.
ಬೈ ಅದನ್ನ ಹೇಳ್ಬಿಟ್ಟು
ಆರ್ಡರ್ ಡೇಟೆಡ್ 24/5/23 ಸರ್.
This code by order dated 24
ID proof ಒಂದು ಅಪ್ಲೋಡ್ ಆಗ್ತಾರೆ
24/5/2023 as recalled that recalling ಏನಿದೆ
ಮಿಸ್ ಆಗಿರೋದು 24/5.
This code by order dated 8/11/2023 has recalled that order dated 24/5/2023. Office has wrongly shown that appeal against the R1 to R8 is dismissed. Office is directed to correct the same. Yes.
Serial number 40. Pradeep Kumar RH for appellant.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರು.
For appellant, my lord.
ಮಾಡಿದ್ದಾರೆ.
Yes.
I have complied with the office objection.
What is that maintainability?
My lord, morning it was been in the morning session, it was been overruled, my lord, with respect to the court fees issue.
ಅದು ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. Yes. Post this matter for admission.
Please, no. Any
Yes.
date may be.
ಅವರು ಬೆಳಿಗ್ಗೆ ತಗೊಂಡಿದ್ದಾರಲ್ಲ ಅವರಿಗೆ ಹೇಳ್ಬೇಕು post this for admission next week.
Number 46, Girish MS for appellant. Number 46, Girish MS.
On arriving of an defendant or through as a trial court, also submission for appeals. Office note. None appear. This matter of 3 weeks.
Number 54, NP Kalesh Gowda. Number 54.
ಬೆಳಿಗ್ಗೆ ಬಂದು ಇದನ್ನ ಏನಕ್ಕೆ ಪಾಸ್ವರ್ಡ್ ಆಯ್ತು?
ಅವರೇ ಪಾಸ್ವರ್ಡ್.
ಎಸ್ ಪಾಸ್ವರ್ಡ್.
In the hearing matter, serial number 72, 73, 74 adjourned, serial number 75, Himaya KH for appellant, V.B. Shivakumar.
Can be taken because paper book is ready in fact. Some of the exhibits, not the
Yes.
learned
The
judge
request
not
of-
after marking has not been signed. Therefore, office is not issuing the certificate copy of the not unsigned exhibit T series. In fact, all the documents are ready except the.
Yes, you file it. Yes. The request of counsel for the appellant leaves this matter of 2 weeks.
Serial number 76, V.K. Vasan for appellant, Randish Koda G.P.
Why, madam? At the request of counsel for the respondent, leaves this matter of 2 weeks.
Number 77 adjourned, serial number 78 adjourned, serial number 79, Vishwanath R. N. for appellant, S.B. Srinivasa. Serial number 79. Serial number 79.
Yes, Vishwanath or Hegde? Yes, password.
80 adjourned, serial number 81, Subramanya H.V. for appellant, Sita D.J.
Paper is not served on the.
Yes, learned counsel for the idea. One paper. You collect it from here, it is there. Yes. None appear for the appellant, leave this matter of 3 weeks. Yes.
Number 82, Tajuddin for appellant, Irshad Ahmad K.
Yes. Yes, Mr. Huh? On time. Yes, learned counsel for the respondent press 2 weeks time. Leaves this matter of
Monday.
next week.
Serial number 83, H. V. Srinivasamurthy, 14% for appellant. Appellant 14%, Ramesh P. Kulkarni.
I'll have to file,
Not filed.
in the memo. For 1,000 pages bulk, they filed the documents. Again, little more.
What is the it is a partition suit. What has happened to that?
Challenging way back, his father executing sale deed, my favor of the year 1914.
You are the family members or an other person?
Family member.
Then why can't we settle that matter? You try for settlement, mister. Why that? You ask that parties if it is both the part refer to that mediation. We'll refer the mediation. Yes. Yeah.
Short date, I will inquire. Take it up Monday.
No, that
Mediation.
you go to that mediation. ಅಲ್ಲಿ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಅಂದ್ರೆ ಅಲ್ಲಿ ನೀವು ಒಪ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ವಾಪಸ್ ಬನ್ನಿ ಅಷ್ಟೇ. Whether mediation in which district it is come from. Then Bangalore Mediation Center. Bangalore, yes. Yes, in the interest of justice and at the request of the parties. The matter is referred to Bangalore Mediation Center. Your party is also from Bangalore. Yavat date ಬೇಕು next month ಅಲ್ಲಿ. ಆಯ್ತು, you can appear on 31st January.
First week.
5th.
Yes.
5th. Parties are directed to be appear before the Bangalore Mediation Center on 5th. Office is directed to send that records to the Bangalore Mediation Center. Let us see. 5th February. If it is possible, you may settle it, Mr. Before the family.
Our ತಂದೆನೇ sale deed ಮಾಡ್ತಾರೆ.
ಆಯ್ತು, ಕೂತ್ಕೊಂಡು ನೋಡಿ if it is mediation it is true and all, let them decide. Yes. Yes.
Number 84, C.S. Prasanna Kumar for appellant, Adinatha Nande.
Prasanna Kumar. Yes, pass out.
Number 85, Arjun. Number 86. For appellant, subject matter, J. Kumar L.
Yes. Yes.
Yeah,
At the request, leave this matter of 2 weeks. Yes. Pass out, finish.
What more matter?
Serial number 86 at the adjournment. You are appearing for whom? Appellant. You are a party in person wants type. Yes. Now he has appeared now. Some person is advocate or lawyer yaru illa ante. Aaytu koda. Yes.
What more matter? Serial number 3, Tippeswamy U for appellant. Serial number 3, Tippeswamy U.
No, that our lawyer illa ante yaro some party in person has appeared. His lawyer has some problem antandru. Then I said 2 weeks. party in person ಅಂತಂದ್ರೆ he is not a party in person who is appearing. He himself has appeared that his counsel has some problem ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Therefore I said party in person representing by the counsel. Our lawyer ಗೆ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸರ್ ಅಂತ he said ಆಯ್ತಪ್ಪ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. You are also not there. I thought that 30th, yes.
Second type Procedural Matters, serial number 3, Chitteswamy Mingu.
Where is that? Yes, Pastor.
Number 4, Krishnamurthy HJ.
Pastor.
Number 5, Anjana Devi PS.
Pastor.
Number 6, Narendra PR.
Pastor.
Number 54, MP Kalesh Goda.
Pastor.
Number 79, Vishwanath R. Hegde for appellant, SP Srinivasa.
Yes, Mr. 79. You are appearing for? Yes. Yes. What is this, Mr.? Yes, Mr. You want passover? Passover. What is that matter, Mr.
It was originally filed as a PNDC. Without making me party, I am also a shareholder in this property. This is a joint family property. The plaintiff in the suit claims that this is a bill was executed by one Nallamma. He did not have any capacity to execute any unregistered bill. A declaration is not a bill of, it is in the form of a declaration saying that this property belongs to a temple. This is an ancestral property. Another suit was filed in respect of this property. That suit has been dismissed. They filed an appeal RSA before this one. And the suit was dismissed and the appeal was dismissed against a concurrent finding. The appeal is filed and RSA is filed before this one. In fact, 2 days back, I filed Vakalat in that.
RSA is also pending. Let us see next week. Yes. Yes, at the request of parties, leave this matter next week.
Number 84, yes, Prasanna Kumar for appellant, Adinath Matre.
Pastor.
ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ ಸರ್. ಇನ್ನೊಂದು ಏನು ಸೇರಿಸ್ಬೇಕು ಹೇಳ್ತೀನಿ. ಬೆಳಿಗ್ಗೆ ಆಗಿದೆ ಹೇಳ್ತೀನಿ. ಅಡ್ಡೇನಾಗೋದು. ಹೇಳು, ಹೇಳು. ಕರೆಕ್ಟ್ ಆಗಿದೆ ಆಮೇಲೆ ವೆಟ್ಟಿರೋ ಅಮೆಂಡೆಡ್ ಆಗ್ತದೆ ಅದಕ್ಕೆ ಈ ಸದ್ಯಕ್ಕೆ ಫಾರ್ಮಾಲಿಟಿ ಅಷ್ಟೇ ಇಂಡಿಕೇಶನ್ ಕರೆಕ್ಟ್ ಗಾಳಿ ಎಲ್ಲಿದೆಯೋ ಅಲ್ಲಿ ಮಾಡಿ ಒಟ್ಟಲ್ಲಿ ಅಕ್ಕಪಕ್ಕ ಇರಬೇಕು ಫಸ್ಟ್ ನಂಬರ್ಗೆ ಫೋನ್ ಬಂತು ಇಡುವಂತ ಸೀರಿಯಲ್ ಕಳಿಸ್ತೀನಿ ಟೇಬಲ್ ಅವ್ರ ಕಣ್ಣು ಕಾನ್ಸಂಟ್ರೇಟ್ ಚೆಕ್ ಮಾಡಿ ಯಾರು ನಾವು ಅಡ್ವೊಕೇಟ್ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದ್ರು ಯಾರು ಇಲ್ಲ ಅದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಅದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ನೀವು ಯಾರು ಅವರು ಬಂದ್ರು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀವಿ ನೀವು ಯಾರ ಕೈ ತಗೊಂಡು ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು ಬೇರೆ ಮ್ಯಾಟರ್ 30ನೇ ತಾರೀಕು ಡೇಟ್ ಇದೆ ನೀವು ಅಷ್ಟೊತ್ತು ಬೇರೆ ಅಡ್ವೊಕೇಟ್ ಯಾರಾದ್ರೂ ನೀವು ಎಂಗೇಜ್ ಮಾಡ್ಕೊಳ್ತೀವಿ ಆಯ್ತು
ಇದಾದ್ರೆ ಈಗ ಹೋಗುದು ಬೇಡ ಇವಳು.
ಸಿಂಧು 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 ಜಡ್ಜ್ ಇಲ್ಲ ಆಂಟಿಗೆ ರೈಸ್ ಅದೇ ಅದೇ ಲಂಚ್ ಮುಗಿಸ್ಕೋಗಿ ಅರ್ಜೆಂಟ್ ಮಾಡಕ್ ಬೇಡ. ಇಲ್ಲಿ ಬಂದು ಎಷ್ಟು ಮಟ್ಟಿಗೆ ಬಂದ್ರು?
79 ಸರಿ ನೋಡೋಣ.
ನಿಮ್ ಫ್ರೆಂಡ್ಸ್ ಯಾರ ಇದ್ರೆ ತಿಳ್ಕೊಬೋದು. ಸೀರಿಯಲ್ ನಂಬರ್ 84 ಅರ್ಜೆಂಟ್.
11 ಅಲ್ಲಿ 79 ಅಲ್ಲೇ ಇದ್ದಾರೆ. 79 ಅಲ್ಲಿ ಇದೆ. ಇಲ್ಲಿ ಪಾಸ್ ಅವ್ರು ಗೊತ್ತಾಗುತ್ತಾ?
ಸುಮಾರ ಪಾಸವರುದ ಸುಮಾರ ಪಾಸವರುದ.
ನಮ್ದು ಎಷ್ಟು ಅಂತ ಹೇಳಿದ್ರಿ ಅದು?
84th ನಮ್ದು.
ಅಲ್ಲಲ್ಲ ಆರ್
RSA
ಆರ್
719
716
ಇದು ನಮ್ದೇ ಅದೇ ಸಾರಿ RFA
981
9 ಇದಲ್ಲ ರಾಜು ಸರ್, ಇದು KV8 ಇದು
ಇರಿ ಇಲ್ಲಿ ಓಪನ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ.
ನಮ್ದೇ ಇರ್ಬೇಕು ಸರ್.
84 716 of 19
ಹಾ
ಪಾಸವರ್ ಆಗಿದೆ.
11 ಅಲ್ಲ 716 of 19. ಫಸ್ಟಿಗೆ ನಮ್ದೇ ಇದೆ ಈಗ.
ಕರ್ದಿದ್ದಾರೆ
ಈಗ ಅಂದ್ರೆ ಕರೆದಿದ್ದಾರೆ. ಕರೆದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. ಆದ್ರೆ 19 20 21 16 1 2 3 4 5 6 7 ಪಾಸ್ ಓವರ್ ಇದೆ. ಅದರಲ್ಲಿ ನಮ್ದು ಒಂದು
ನಮ್ದೇ first.
17 ನಮ್ದೇ ಫಸ್ಟ್. 79 ಯಾವುದು? ಇಷ್ಟು ಬೇಗ ಹೊರಟ್ರ? ಲಿಸ್ಟ್ ಮುಗೀತಿದು. ಓ ಮೈ ಗಾಡ್. ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಇವತ್ತು ರೀಚ್ ಆಗಲ್ಲ ಅಂತೇಳಿ ನಾವು ಅಂದ್ಕೊಂಡದ್ದು. 85 ಸುಮಾರಿದೆ ಫೈನಲ್ ಇಯರಿಂಗ್ ಅಲ್ಲಿ. ಸುಮಾರಿಲ್ಲ, 72ರಿಂದ ಫೈನಲ್ ಇಯರಿಂಗ್.
ಅಟ್ಲೀಸ್ಟ್ 4 weeks ಟೈಮ್ ಕೇಳ್ಬೇಕು ನೀವು. ವೆಕೇಶನ್ ಗಿಂತ ಮುಂಚೆ ಬಂದಿತ್ತು ಕಟ್ಟಿದ.
ಕೃಷ್ಣಕುಮಾರ್ ಒಂದೇ ಒಂದು ಎರಡು ಸಲ ಟೈಮ್ ತಗೊಂಡೇವ.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಸತ್ಯನಾರಾಯಣ್ ವಾಸ್ ದೇರ್.
ಹಾ,
ಅವ್ರೇನೋ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ರು, ಅವ್ರು ಎದ್ದು ಹೋದ್ರು ಸಾಹೇಬ್ರು.
ಹೌದಾ?
ಏನು ಕೇರ್ ಮಾಡಿಲ್ಲ. ಅವ್ರೇನು ಇಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಇದ್ದಾನೆ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ತಲೆ ಎದ್ದು ಹೋದ್ರು ಅವರು.
ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ನಮ್ಮನ್ನು having regard to the fact that parties
ಆಯ್ತಪ್ಪ ನಿಮ್ದಾಯ್ತಾ? ಬ್ರಾಂಚ್ ಹಾಕು. RFA ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಯಾಕೆ? ಹಾ. ಸರಿಯಪ್ಪ. ಸರಿ ಸರಿ.
ಆಗಿಲ್ಲ ಅಲ್ಲ ಆಗಿಲ್ಲ ಇದು ಆಗಿಲ್ಲ ಇದುವರೆಗೆ ಪಾಸ್ಪೋರ್ಟ್ ಹೋದ್ರೆ
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಆರಕ್ಕೆ serial number 11 872 Serial number 3, replace from you for apparent. Serial number 3, replace from you.
ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದೆ, ನೆನ್ನೆ ಬಂದಿದ್ದ
ಇಲ್ಲ ಸರ್
ಡೇಟ್ ಅಂತ ಬಂದಿದೆಯಲ್ಲ ಅದು ಬಂದಿದೆ. Matter is posted for non-compliance of office objection for 6th time. The matter is called in the morning session. None appear for the appellant. During the afternoon session, when it is called, none appear for the appellant. For this matter tomorrow, the orders at top of the list.
Number 4, Krishnamurthy HJ.
This court by order dated 7th August 2022 dismissed that appeal for non-prosecution. IA-1 of 2023 is filed for recalling that order dated 17/8/2022. The matter is posted for orders. Consider IA-1 of 2023 3/1/2024. None appear for the appellant. Directed to be posted today for orders at top of the list, even today. When the matter is called, none appear for the appellant. It appears that appellant is not interested in prosecuting this appeal. It's IA 1 of 2023 is dismissed for non-prosecution.
Number 5, Janadevi, GS for appellant.
This court by order dated 12th June 2023 dismissed the appeal for non-prosecution. IA number 1 of 2023 is filed for recalling that order dated 12th June 2023. When the matter is posted on 11/8/2023 on IA to consider IA 1 of 2023, on that day, none appear for the appellant. IA 1 of 2023 is dismissed for non-prosecution. To recall that order dated 11/8/2023, IA 2 of 2023 is filed. IA 2 of 20 for condonation of delay of 96 days. 3 of 2023 is filed for recalling that order dated 11/8/2023. When the matter is posted for orders on IA 2 and 3 of 2023 on 3/1/2024, none appear for the appellant. Office is directed to post this matter today at the top of the list for orders. Even today, when the matter is called twice, none appear for the appellant. Hence, IA 2 and 3 of 2023 is dismissed for non-prosecution.
Number 6, sir, Narendra B.S. for appellant, Sudhindra B.S.
ಎಷ್ಟನೇ ಸರಿ ಬಂದಿತ್ತು ನೆನ್ನೆ ಕಂಪ್ಲೇಂಟ್ ಸಿಗಿದೆ. Matter is posted on 3/1/2024 for non-compliance of office objection for 5th time. The matter is called twice, none appear for the appellant. Hence, office is directed to post this matter today at the top of the list for orders. Even today, when the matter is called twice, none appear for the appellant. Please this matter tomorrow at the top of the list under the caption for dismissal.
Serial number 54, NP Ganesh Gowda for appellant.
Yes, Mr.
Expired on 17. Challenging the orders of the Constitution. Filed by the appellant. Office objections have been complained. Subsequently, the officer has raised regarding preliminary issue of the hearing. That was not available on that day. So, in the course of the day, complaint ಮಾಡಿಲ್ಲ. So, we have complained on entire office objection complaint ಮಾಡಿ.
ಏನಕ್ಕೆ ಪೋಸ್ಟ್ ಆಗಿದೆ ಇದು? Recalling the 17-4. What is that 17-4 order?
This is the appeal for the non-compliance of.
Register.
ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್?
Office objections. ಎಲ್ಲ office objections complaint ಮಾಡಿ. preliminary issue ಮೇಲೆ ಏನು dated 6th January 2017 and preliminary issue ಮೇಲೆ
Copy of the finding issue number 7 and additional issue number 2 to be filed. ಹಾಕಿದಿರಾ?
ಅದನ್ನ ಹಾಕ್ಬೇಕು. ಅವತ್ತು ಪಬ್ಲಿಷ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅವತ್ತಿಗಿಂತಲ್ಲಿ ಎಂಟೈರ್ ಅದರ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್
the complaints ಅದು ಒಂದೇನಾ?
ಅದೊಂದೇ ಅಬ್ಜೆಕ್ಷನ್.
Value of the appeal plaintiff shares exceeding about 15 lakhs hence second set of appeal papers should be filed.
ಮಾಡಿ
ಎಲ್ಲಿ ಸೆಕೆಂಡ್ ಸೆಟ್?
senior has expired. This appeal is filed by Chandraprabha Antava. Here the colleague now file money. Both my name and Chandraprabha name.
You will appear for them, your senior. ಅದೇ ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ? ಕೊಡಿ. You have in a file? Yes. ಅದು ಕೊಡಿ. ವಕಾಲತ್ ಕೊಡಿ. He is also there practicing, Chandraprabha. Chandraprabha is, yes, he is practicing. You are in the same office.
No, my senior has given this file to Chandraprabha to file. Because the file was there, subsequently I corrected, I have completed the office objection part. Subsequently, this matter is there.
Now, by who is looking after this matter?
Both names may kindly be shown, my lord, I will inform the party.
Yes.
It
is submitted at the bar that counsel for the appellant NP Kallesh Gowda is no more. Office is directed to delete the name of NP Kallesh Gowda, show the name of T.S. Chandraprabha, the net counsel, and what is your name? G.A. Srinivas. Your name is also there. G.A. Srinivas, counsel appearing for the appellant. Pending consideration of IA 1 of 2023. 2 weeks time is granted to comply the top subjects. Yes, you do it.
Number 684, yes, Prasanna Kumar for appellant, Adinath Nath.
Yes.
Speaking for adjournment. I produce a medical certificate with respect to.
What is this matter, Mr.? You are the plaintiff or a defendant? Plaintiff. Why?
Only one house, one residential property and 4 portions. ಮೊದಲನೇ 2 portions ಅಲ್ಲಿ ground floor ಅಲ್ಲಿ ಒಬ್ಬ ಬ್ರದರ್ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಒಬ್ಬ ಬ್ರದರ್. ಇನ್ನೆರಡು portions ಅಲ್ಲಿ ಒಬ್ಬ ಸಿಸ್ಟರ್ ಒಬ್ಬರು ಇನ್ನೊಬ್ಬ ಸಿಸ್ಟರ್ ground floor ಇದ್ದಾರೆ. ಯಾವತ್ತೂ ಪಾರ್ಟಿಷನ್ ಆಗಿಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಔಸ್ಟರ್ ಆಗಿದೆ. ಬೈ ಮ್ಯಾಸಿವ್ ಅಕ್ಸೆಪ್ಟೆನ್ಸ್ ಔಸ್ಟರ್ ಆಗಿದೆ. ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತಾರೆ ಔಸ್ಟರ್ ಆಗಿದೆ.
What is that issue framed by the trial court? What are the issues? Whether the plaintiff prove that sued properties, joint family properties, negative ಮಾಡಿದ್ದಾರೆ. Plaintiff prove that negative. Plaintiffs are entitled for the relief. Why it is not a joint family property?
ತಂದೆ ಪ್ರಾಪರ್ಟಿ ಅಲಾಟ್ ಆಗಿರೋದು PDA ಇದೆ. ತಂದೆ ತೀರೋಗ್ತಾರೆ, ತಾಯಿ ತೀರೋಗ್ತಾರೆ. ಸೊ 4 ಜನ ಮಕ್ಕಳು ಪಾರ್ಟಿಷನಿಂಗ್ ಮಾಡಿ. ಈ ಏನ್ ಇಶ್ಯೂಸ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ರೆ ಏನ್ ಒಪಿನಿಯನ್ ಡ್ರಾ ಮಾಡ್ತಾರೆ ರೀಸನಿಂಗ್.
No, now that one there are 2 children are one side and 2 are other side.
Sisters and 2 brothers.
2 brothers.
Staying in their respective portions. One check would be what they ಹೇಳಿದ್ದಾರೆ. They are all staying in their respective portions now. There is no urgency, my lord.
Yes. No, one portion says 4 persons are in the different portions, but is there equal share?
ಇಲ್ಲ.
1/4 share ಇದೆ.
ಅಲ್ಲ 1/4 ಶೇರು ನೀವು ಅವ್ರವ್ರು ಇದ್ದಾರೆ ಅಂತ ಅಂದ್ರೆ ನಿಮ್ದು ಅವ್ರಿಗೆ ಬಿಟ್ಕೊಡಿ, ಅವ್ರು ನಿಮಗೆ ಬಿಟ್ಕೊಡ್ತಾರೆ. ಹಂಗಾರೆ if it is in equal, where is the finding of the trial court? You read that issue number 1 and 2. 2 issue. Yes.
Issues are considered as they are underneath. At the risk of repetition, stated that there exists 4 residential units. 2 outhouses in the ground floor and 2 first floor, second 2 main houses similarly in ground and first. First plaintiff is in first floor outhouse. Second plaintiff in ground floor outhouse. Outhouse consists of 2 rooms or kitchen. Brothers of the plaintiffs are in possession of first and ground floor main house. 4 units are entered by the plaintiffs and defendants living is more than 13 years. It has come to the evidence of PW1 that PW1 is residing in the ground floor outhouse and our elder sister that the main house will construct itself. PW also admits that there exist 2 bedrooms in the house where person is residing. By their mother got converted the ground floor as bedroom, and thereby even she has been accommodated to outhouse consisting of 2 bedrooms. Everyone in para 4 of the states that all the parties to the suit are contributing proportion. Everyone is that defendants have developed their portion of houses and voluntarily states that there is no partition in respect of what is PW1 established that the invites ways by paying their portion of taxes from physics from the date under for a period of more than in not making any claim for more than 29 years, even after death of their father or during the lifetime of their mother, who died prior to 12 years of the date of this suit for any share in the suit property or income in the property, in the amount of the passive acceptance of right of the dependents and also the arrangements made during the lifetime of their parents who accommodated their children in individual needs. Plaintiffs admittedly not claimed any share even during the lifetime of their. Also, coming the evidence of PW1 that her mother believed that in the outhouse accommodated to first plaintiff in the first floor bedrooms and in the ground floor he was in possession of existed only 1 bedroom. She converted the garage into bedroom and maybe 2 bedroom house for deciding separately a portion of taxed houses in their possession. To be understood continuously for more than 30 years amounts to acceptance of the right. PW1 admits that there is no doctrine for adding the right with dependents on the 3/11/2011 or 5 years prior to that. In the 8 of the plaintiff in the second. PW1 admits in the cross-examination that they are deciding their portion of the houses without any interest from the dependents. This was contradictory version of 19 also establishing that there is no cause of action to file the suit. The acts if coupled with the exclusive possession of the parties is sufficient enough to hold that there is massive acceptance on behalf of plaintiff amounts to an house. I mean, not the limits of houses individually by paying their portions of taxes. Plaintiffs made to establish existence of any joint family and their 1/4 main distribution power. Also examine the benefit not approved this book next.
No, what if they are residing separately? Is it mean that they are not a joint family? What is the law on that point? Is there any judgment?
I also refer to judgment.
What is that if they are separately residing in the different portions? Is it time that is
Partition. Any long possession and it only amounts to a maximum a domestic or a family arrangement, which cannot be considered as partition.
yes? You have not cited any judgment before the trial court.
That judgment is not considered.
What is the defense of the defendant in that written statement?
Moral part. It doesn't mean even the correspondence adverse possession also.
Records in it. It appears, madam, court has just because if they are residing separately, unless it shows that it is better, you can settle that matter. It's all before the family members. Portion. See, you can see that if they are there in that different position, that cannot be disturbed. If persons who has more portions of the property can compensate by paying some amount and all, that can be adjusted. Now property cannot be divided because they are residing in their own. Only thing is that so a small difference that can be by adjustment, or that these two are the sisters, they can pay some amount and they can be settled. They can say that. ಆಯ್ತ್ರಿ ಅವ್ರೇನ್ ದೊಡ್ಡ ಶ್ರೀಮಂತರೇನಲ್ಲ ಕೆಡಗ್ಬಿಟ್ಟು ಬೇರೆ ಕಟ್ಟೋದಕ್ಕೆ. ಈಗ ಈ ಮನೆ ಕೆಡಗ್ಬಿಟ್ಟು ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿ ಅಂದ್ರೆ ಅವರೆಲ್ಲ ಎಲ್ಲ ಹೋಗ್ತಾರೆ. ಈಗ ಎರಡೆರಡು ಮೂರು ಮನೆ ಇರೋರಾದ್ರೆ ಇನ್ನೊಂದು ಮನೆಯಲ್ಲಿ ಮಾಡ್ತಾರೆ. ಈಗ ಸೇಮ್ ಪೊಸಿಷನ್ ಇಸ್ ಆಲ್ಸೋ ಯುವರ್ ಬ್ರದರ್ಸ್. ಐ ಥಿಂಕ್ ದೇ ಆರ್ ಆಲ್ಸೋ ನಾಟ್ ಎನಿ ಬಿಸ್ನೆಸ್.
ಈಗ ಓರಲ್ ಪಾರ್ಟಿಷನ್ ಅಂದು ಅವರೆಲ್ಲರೂ HAL ನಲ್ಲಿ ಇದರಲ್ಲಿ BDA ನಲ್ಲಿ ಒಂದು ಸೈಟ್ ಅಲಾಟ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ. ಈ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಅಲಾಟ್ ಮಾಡಕ್ಕೆ ಬರಲ್ಲ, ಅಲ್ಲೂ ಅಲಾಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ BDA ನಲ್ಲಿ.
ಆಯ್ತು, ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿರೋದು ಲೆಟ್ ಇಟ್ ಬಿ.
ಅದಕ್ಕೆ ಲೆಟ್ ದೆಮ್ ಎಂಜಾಯ್.
ಫ್ಯಾಮಿಲಿ ಪ್ರಾಪರ್ಟಿಲಿ ಯು ಸಜೆಸ್ಟ್ ಯುವರ್ senior and client also can better sit it together, sit like this. I don't think judgment certain proper this thing. What is that? Your case is that oral partition. Then burden on you to prove. Nothing is there in your evidence. Only on his evidence court has passed an order. Elli written statement elli. There should be an issue on that whether defendant has to prove. Then we have to send it back. Then it will again complication. Instead of that, you can sit and decide where is that written statement. ಎಷ್ಟನೇ ಇಸ್ವಿ ಸೂಟ್ ಇದು? 2012. ಇದು 5 ಆದ್ಮೇಲೆ ನೀವು ಯಾಕೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಸ್ವಲ್ಪ ಕೊಟ್ಟು. ಆಯ್ತು, ನಿಮ್ ಕಂಟೆನ್ಷನ್ ನಿಮ್ ತಂದೆನೆ ಎಲ್ಲರಿಗೂ ಶೇರ್ ಮಾಡಿ ಹೋದ್ರು ಅಂತ. ದರ್ ಶುಡ್ ಬಿ ಅನ್ ಇಶ್ಯೂ ಆನ್ ದಟ್ ಪಾಯಿಂಟ್ ಅಂಡ್ ಯು ಹ್ಯಾವ್ ಟು ಎಸ್ಟಾಬ್ಲಿಷ್ ಬೈ ಎವಿಡೆನ್ಸ್. ಅದು ಮಾಡ್ಲಿಲ್ಲಲ್ಲ, ಅವ್ರದ್ದು ಎವಿಡೆನ್ಸ್ ಮೇಲೆ ನಿಮಗೆ ಇದು ಮಾಡ್ಬಿಟ್ಟು. Yes, your case is that when the parents was there, they have given a partition. If that is the true, then if it is established, then he don't have any case. But that was not the issue. Yes. You also put across your senior saying that it can be settled between the parties. Since plaintiffs are sisters, you brothers are.
Dependents
When a different amount idre, they can settle also. Yes, Mr. That is also possible. Now everything is separate. You have your own ಏನು ಹೌಸ್ ನಂಬರ್ ಎಲ್ಲ ಬೇರೆ ಖಾತಾ ಗೀತೆಲ್ಲ ಬೇರೆ.
ಏನು ಆಗಿಲ್ಲ, ಖಾತಾ ಸ್ಟಿಲ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ಇನ್ ದ ನೇಮ್ ಆಫ್ ಫಾದರ್ ಓನ್ಲಿ.
Then how can you say that?
ಬೈಫರ್ಕೇಶನ್ ಆಗಿಲ್ಲ.
ಈಗಿರೋ ಪೊಸಿಷನ್ ನೀವು ಮಾಡ್ಕೊಂಡು ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಕೊಟ್ಕೊಂಡು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೋಬಹುದು. ಆರ್ ದಟ್ ಇಫ್ ದೇ ಆರ್ ಆಲ್ ಕೇಪಬಲ್ ಕ್ಯಾನ್ ಡಿಮಾಲಿಶ್ ಅಂಡ್
ಅಷ್ಟೇ, ಎಲ್ಲರೂ ಈಕ್ವಲ್ ಆಗಿ ಏನಾದ್ರು ಮಾಡ್ಕೊಂಡು ಈಗೆಲ್ಲ ಮಕ್ಳುಗಳು ರೆಡಿ ಆಗಿಬಿಟ್ಟಿದ್ರು.
ಅದರ್ವೈಸ್ ಇದೇ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರು ಮತ್ತು ನೀವು ಒಬ್ರು ಹೊಡಿಬೇಕು ಅಂದಾಗ ಇನ್ನೊಬ್ಬ ಬೇಡ ಅಂತಾರೆ, ಇನ್ನೊಬ್ಬ ಹೊಡಿಬೇಕಂತ. ಎಸ್ ಲೆಟ್ ಅಸ್ ಯು ನೆಕ್ಸ್ಟ್ ವೀಕ್. ವೈ ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್? Who is that arguing? Huh? Not well. What has happened? Not necessary.
No, madam, please.
No, what has happened, madam? I am asking them the concerns. Yes, she is not well. But yes, leave this matter first week of February. 12th February, madam.
Please.
Yes. You also speak with her senior and say that is there any possibilities of getting? Yeah.